Yes, no one? No one? None appears for the appellants. Paragraph, let the matter appear under the same heading on next week. Next week. Let it remain in the next week. Yes, I think Ms. Nag is appearing in this matter. Yes. Please wait. Yes.
Suit was filed in 2000. In the year 2000, the suit was filed by the plaintiff claiming share in the property. I have specifically raised the point of limitation. In my written statement, as well as in the argument also, the point of limitation has been taken. But both the courts, Your Lordship, did not look into the point of limitation. At least adjudication has to be done. And I'm relying upon the decision of the Honorable Supreme Court exactly to this particular issue. Your Lordship, may kindly look into it. Paragraph 37 may be seen. 37 and 38.
You say that the mutation application was beyond time.
Mutation application was filed by my client sometimes in 1980s, and that was allowed in 1985. And these people, the legal heirs of the original owner, they have rendered their no objection at that relevant point of time. And thereafter, mutation was done in favor of my client. That my client also died. Those legal heirs, one of the legal heirs, he also died. Then in 2000, some of the legal heirs of the original owner and the grandchildren of the original owner, they filed a suit for declaration of title. I raised a point that it is barred by limitation because mutation took place in 1985, and I have not only acquired the right, title and interest in the suit property, I have mortgaged the suit property also in the bank. That mortgage also was realized from my income. And moreover, I am paying the land revenue since 1985. I have been paying the land revenue. They have never shared the land revenue at any point of time. So when I have taken a point of limitation, at least it should be adjudicated. Both the court did not adjudicate. Your Lordship, may kindly see the.
Please come to the relevant judgments. The
Yes.
relevant judgments.
Yes. It starts from page number 36, Your Lordship.
Sorry, 36. 36 of the trial court judgment.
Yes, Your Lordship. Inner page would be page number 9.
Yes. This suit was filed in 2011,
No, 2000, in 2000.
but it's TS 49 of 2011.
Yes, Your Lordship, when the matter is transferred to another court, the number changes. But it was filed in
How can
2000.
it go back to 2011?
It was filed in senior division. So that number was given of 2000. Then when it was
the
transferred,
order is, the judgment is also 2011.
maybe there is some mistake.
30th August 2011. Oh, it's 2022. It's not very legible, actually.
The first one, appeal was disposed of on 12th July 2022.
The
Page number
suit
24.
was in 2011.
2011. But the suit was filed in 2000, Your Lordship.
How?
I'll show that. Just a minute.
The year should have been mentioned as 2000 in that case.
This is mentioned as 2011 because generally when the matter is transferred from senior division to joint,
Yes, but
The
the
number-
year doesn't change. The
here
number
it is-
changes.
here, Your Lordship, they're changing the complete thing. When it is transferred, that year they are mentioning. That should not have been done, but that is what is the practice.
So the year of transfer is mentioned.
Yes,
Very well. Yes. Page 7 of the judgment.
yes, Your Lordship. Inner page starts from page number 7.
You are Shefali Das.
Your Lordship.
Have you raised the point of limitation?
Yes,
before,
Your Lordship. I'm showing you. This is the entire bunch, Your Lordship. Plain written statement, everything. Your Lordship, may kindly come to page number 58. This is the written statement. It starts from page number 54. That is the written statement. And paragraph 14 may be seen, Your Lordship. That with reference to the statement made in para 14 of the said application, there is no cause of action at all arose for filing the instant suit. The plaintiffs have come forward with claim over the land after a gap of more than 30 years. The plaintiffs had the knowledge that the suit land has been mutated in the name of Motilal in 1985. The suit is barred by limitation and is not maintained. Specifically alleged,
this point is not dealt with.
not at all dealt with either by the first court or by the appellate court, first appellate court. Moreover, Your Lordship, I have documents to show which has been exhibited without objection that in 1986, I have executed a power of attorney in favor of Satyabhan Das, that is one of the plaintiffs. And so they can't say that they have no knowledge. For the same property, I have executed a power of attorney in his favor to deal with the land. So they can't say that they had no knowledge about it.
It is contended on behalf of the appellants that the property in question was mutated in favor of the husband of the appellant.
Motilal.
That's the husband of the appellant.
Yes.
In favor of the appellant's husband, Motilal Das, since deceased, sometime in 1985. Stop. The respondents filed a suit challenging the mutation.
No, for declaration of title.
Filed a suit
For
for
declaration.
declaration of their title in respect of the said property
In the year 2000, Your Lordship.
That I do not find the year
Yes.
2000.
In my bunch, Your Lordship, I have annexed the plaint,
Page number?
page number 30. This is title suit number 39 of 2000,
This is before the civil just senior division.
senior division. And when it was transferred to joint, then the year of transfer, they have mentioned it as title suit number this of 2011.
Please repeat the sentence. In respect of the said property, not suit property, said property sometime in 2000, stop. The petitioner raised an issue of limitation before the learned trial court on the premise that despite having knowledge of the mutation of the property in favor of the petitioner's husband, comma, the respondents chose to file the suit after inordinate delay, which was not explained by them in the suit. Stop. The learned trial judge did not take into account the issue of limitation raised by the petitioner and decreed the suit in favor of the present respondents. Stop. The judgment was carried in appeal by the petitioner herein, and the appellate court dismissed the appeal without taking into consideration the issue of limitation raised by the appellant therein. Paragraph. Upon consideration of the submission made on behalf of the appellant as well as material on record, comma, we are inclined to hold that the appeal shall be heard on the following substantial question of law formulated by us. Number one, have the trial court and the appellate court erred in law in disposing of the suit and the appeal without taking into consideration the issue of limitation raised by the appellant in both the suit and the appeal. That should be sufficient.
That is it.
Right. Paragraph, the appellant is directed to serve copy of the appeal along with annexure thereto upon the respondents by speed post and file affidavit of service on the adjourned date. Paragraph, next circuit, because I don't think you'll be able to come back before this before us.
Next
Let
circuit.
it be, yes. Paragraph, the matter be placed before the next available circuit bench.
Oblige, Your Lordship.
Yes, yes. There should be direction for paper books also, isn't there?
Yes, Your Lordship, there has to
Yes,
be a direction
yes,
of paper.
yes. Please add that. The appellant is directed to prepare requisite number of paper books within 4 weeks from date.
Your Lordship, 4 weeks.
Yes.
Sufficient. Yes, yes. I have all the
Within
papers.
4 weeks from date.
Oblige.
Yes.
That's it.
Sought instruction. Whether they have obtained or not, or whether they are instant.
Right, right, yes.
That's it. In this case, the order is known as a nullity in the eyes of law, and it is not executable, capable of being executed as per section 82 subclause 3 subclause B. Says of CPC says if a decree is capable of being executed under the provision of this
CPC.
code or any other law, but time being in force. If it were a decree, here in any other law is the land revenue land reform regulation, where it is a
You are referring to
Completely
section 82?
subclause 3, subclause B. Here it is a completely nullity decree, and if a suppose, my lord, if a, for example, if a court directs to demolish a building, and if the authorities reaches and found that there is no building exists, so it cannot be executed.
Was the suit against the government or against any public officer?
No. It is
So how
not,
is section 82 applicable? Please come to the
Here-
first line of the section, sir.
where this it is suit or against by or against government or against a public officer in respect of any act purporting to be done by him in his official capacity.
So how is
Yes.
this applicable? It's not against the government or against any public officer.
Yes.
You want to intervene.
No, we don't want to intervene. We have been directed by the Hon'ble High Court single judge
To
to
implement.
implement the order. We are not, we
Yes.
were not the
Because
party
the
at all.
order is not under challenge.
We are not the party at all in the suit. For the first time,
But you are bound by the decree, sir, because you have not challenged it.
we are not the party to the suit, my lord.
Is it necessary? 82 is not applicable in your case, right?
Yes.
Let us come
Even
to the
then,
order
when the
review.
degree is not executable,
There is the provision.
the provision is that regulation,
Yes.
regulation, if the land is below 200
In that
square
case,
meter.
you have to, I understand, sir. In that case, you have to challenge the decree itself. You cannot challenge the implementation of a decree which is in existence.
But
The
we are not
decree
a
stays
party
at
to
our
the suit.
pace. Yes,
We are not a party to
you
the
have to
suit.
ask for special leave. You are aware of the provisions of law.
Why not it's permissible under law?
Yes,
They
yes.
cannot be an agreed party so much in this concern. What-
Yes, my lord.
No, no, if they're challenging it on legal issue, on a legal point, they can ask for,
They have to demonstrate.
they have to, yes, they have.
This is too sensitive.
And it's absolutely within the domain of the first appellate. A decree which stares at our face, right? Can a court, any court for that matter, stop execution of the decree or implementation of the decree?
No, if it is not at all implementable.
Who
We are-
will
we
say
are-
so, sir?
As per the regulation, we cannot implement the decree.
I understand, you have to challenge in that case.
My lord, we are
You are
not a
sitting, you
party
are
to the
sitting
suit.
over this.
We
You
are
are
not a
aware of
party.
the provisions of law, how to challenge when you are not a party to the suit? Yes, you have to ask for leave, simple. In the present matter, I don't think this court can help you. If you still want to continue, I'll pass an order. That's why I've given you the opportunity to take instructions yesterday, isn't it?
My lord, liberty was given to challenge the
Accordance with
degree.
law.
No,
Liberty is always there in statute. It's already in the book.
no, we are not the party to the,
They can always take out the application before the first government.
we are not a party to the suit.
So you'll withdraw this and I'll grant you liberty to challenge in accordance with law.
Yes.
Yes. I have to dismiss this as not maintainable, sir. I'm sorry.
My lord, in the
Yes.
there is no need for my lord can pass an order giving liberty
Pass an order what? I have to dismiss
to
the.
challenge
I have to
the,
dismiss the.
then
appeal in that
the
case.
implementation of degree has to be stayed, my lord.
No, how?
Already
Cannot be
pattern has been filed. Just to escape from.
It has to be- no.
This is an order of 2022.
Only
So in 2023, end of 23, I cannot stop implementation.
no, my lord, this is order of 2015.
The implementation order, I'm not concerned with the 2015 order at all, because that is not before me, that is not under challenge. The order of the single judge is under challenge, isn't it? That
Why
was
not?
passed on in March 2022.
2022.
When have you filed this application, this appeal?
This appeal we have filed,
July 2023,
my lord,
after expiry of more than a year.
my lord.
So how can you expect an interim order at this stage? You cannot.
My
You
lord,
only dismiss it as not
my lord,
mentioned.
this
That's
appeal
all.
has been admitted,
Maybe
already
you have
admitted.
not sought an interim order at that time.
We have sought, my lord.
So it was not considered.
Stay application is there.
I
No,
do
no,
not
they have
find any.
sought time. They have sought time to file affidavit in opposition.
Yes, I do not find any
They
other.
sought time to file opposition to our stay petition. That is why matter has been adjourned.
Just one line order.
Yes,
Yes, yes.
yes. Thereafter, next date, they have to pay
Yes,
time.
they sought to file affidavit in opposition.
Hmm.
That's there, that's recorded in the order, but no stay was either prayed for or granted. So at this stage, I cannot grant an interim. I have to, because the writ petition, the
This-
appeal prima facie is not maintainable at all. So I have to
Why?
pass an order dismissing your appeal.
No,
Yes,
it is the order itself nullity, my lord, decree itself nullity, and there is no.
how do you know, how do you say that the decree is a nullity, sir? Sir,
No,
repetition, isn't it?
my lord,
Reiteration of your.
my lord, the authorities cannot go beyond the rules of the
Can-
regulation.
Go beyond the decree.
A decree itself is reversing the rules.
Have you challenged it?
Madam, we
It
are
was
not the
sentence-
parties, it is between
So
the
you
private
say that there
respondent.
is no provision for challenging a decree by a person who is not a party, but is aggrieved.
Madam, we are not agreed by the decree
You are
also.
aggrieved by the order of implementation.
My lord, we cannot implement, that is the reason we have filed an appeal before the challenging
Cannot be
before the.
considered. I'll only ask you to implement. There is no ground. The decree is not under challenge. It stares at our face. You have only asked to stop implementation, which cannot be done. This is the reason, sir. That's why I asked you to take instructions. We are spending so much of our time on a matter which is not maintainable for this court. Yes, I'll dismiss it. Take necessary steps.
My lord.
I can still ask you to withdraw and approach the appropriate forum.
My lord, I cannot withdraw, my lord, because execution is hanging on my head. Contempt is hanging on.
You need to face contempt and nothing to do. Sir, anything to add? It is contended on behalf of the appellants. No, not this. The appellants have assailed the order of the learned single judge passed on March 22, 2022 in WPA 25 of 2022, directing the Deputy Commissioner, South Andaman District, Port Blair, to comply with the judgment and decree passed in title suit number 17 of 2012 within a period of 8 weeks from date. Stop. The appeal was preferred only on 18th July 2023. Stop. Paragraph. Learned counsel for the appellants contends that the judgment and decree in question is not, are not executable in view of Rule 48.
My lord,
Rule 48. Clause A of the notification issued on 1st April 1968 by the Chief Commissioner's Secretariat, Andaman and Nicobar Administration, as amended by a notification dated 17 January 2018. Paragraph. The judgment and decree have not been challenged by the appellants before the appropriate forum. Paragraph. In view of the above, we are inclined to hold that since the judgment and since the unchallenged judgment and decree passed in title suit number 17 of 2012 still holds the field, comma, there is no infirmity in the order passed by the learned single judge which requires interference by this court. Implementation of the judgment and decree cannot be stalled unless the judgment and decree themselves are assailed. Paragraph. The appeal being MAT 22 of 2023 is accordingly dismissed. Paragraph. There shall however be no order as to costs.
Connected stay application.
There is a stay application.
Yes.
The connected stay application being can one of 2023, there's only one application. Is also disposed of. Or is it repetitive sense?
Oblige, my lord.
Sorry.
My lord, oblige.
Next.
All this having this serve, this is an application questioning the timeline of the project value.
And I am for the
Yes.
respondent, I'm praying for not today, this my senior will be available tomorrow. Madam. This matter won't going to take a long time. Madam. So according to, otherwise I'm ready, but your lordship knows that I can't. No, but I can't be in my absence.
Can we start today?
That we can do.
Yes.
I do not get influence with this phrase compassionate appointment, because my case purely based on that. Because I cannot claim as a matter of right. There has to be a governing policy. If my case falls within that policy, I'm entitled to be considered for a favorable motion. Now, this petitioner father was working under the respondent's authorities. He died during the service tenure. A request was made to the police department to deploy the present petitioner under the compassionate appointment. Lordship, I have brought few judgments. Those judgments really are against me. But there is one thing which supports me is that, Lordship, if in terms of the policy, the authorities can consider my case. The requirement would be, Lordship, there are 2-3 exceptions being carved out. One should not be delayed in approaching the authority in claiming compassion. There are judgments on these lines. There are judgments in certain line which says that if any of my family members are earning, then I cannot claim compassionate appointment. These are the main 2 grounds in which those judgments are there. Now, so far as the present petitioner is concerned, none of his family members are earning members. This is one thing. And my approach to the authorities was prompt. I'll just give the date, Lordship. When my father died, I'll just give that date. On 8th of just one second.
April 2014, I think.
Yes, Lord. I made the representation to the authorities Lord could find, because I have annexed the original application as well as the opposition which they have used before the tribunal. I'll just show my application, Lord. It's at running page 44, my lord. Running at the top, running page 44.
This is your first representation.
First, that's the only representation I made to the authorities, enclosing all the documents. And based on this representation, the authorities have acted. They have acted in the manner which would be evident from page 42 and 43, preceding pages. (42) and 43. First is of 17th December 2015. The letter which is addressed to my client Sanjay Bahadur, will not could find at the bottom my name. I'll just place this note. It's in the form of a memo with reference to an application requesting appointment in police department on compassionate ground dated 21/7/2014. You are hereby informed that your case was placed for consideration before the committee met on 24/9/2015, and your case was carefully examined but not considered. Further, you are informed that few positions of Home Guards volunteers are available in the Home Guard organization. If you are interested and willing to enlist as Home Guard, may give your willingness to the undersigned at the earliest. Now, I am concerned with Lordship, any job which suits my
Have you
qualification.
replied to this letter, this
Lordship,
memo?
there's no such reply. I approached the authority with the request, you just give me any job. Lordship, then page 43 came to be passed. Page 43. With reference to your, it's also a memo. It's addressed to my mother, Vijay Lakshmi.
Yes.
With reference to your application regarding appointment on compassionate ground in Andaman Nicobar Police, you are hereby informed that your case was placed before the screening committee on 25/5/2018 for consideration along with others. Your cases has been carefully considered on merits, but not recommended by the committee. Hence, your request for compassionate appointment is not heeded to.
The mother requested for the son or for herself?
Yes,
For the
son,
son.
son only. This is based on the representation which my mother given, requesting the authority to give the job to the son. One letter is addressed to the petitioner directly to the son, the other one at page 43 to the mother. Not the tribunal was approached. When nothing was done, tribunal was approached. Approach was made to the tribunal as far back in the year.
No correspondence between 2015 and 2018?
Nothing. The tribunal, by order impugned, endorsed the view, which would be evident from page 43 and 42, 42 and 43, that my case was placed before the screening committee and it was not considered. But there is no iota of evidence placed in their opposition.
42 and 43 are diverse opinions.
Lord.
They are contradictory.
Yes. The ultimate paragraph at page 42 gives me some right to enlist myself in the Home Guard.
Yes.
But Lordship, I approached, even that was not considered. They 2018, they say no, it can't be done, even on the compassionate ground. Two views were taken. Even Lordship, I have challenged both these and have sought appropriate lead before the learned tribunal. The impugned order was passed by the learned tribunal on 15 September 2023. My lord, kindly see the last documents. It's a certified one. I have not paginated it. The same view, which would be evident from page 43, was taken. My case was placed before the screening committee and it was not considered. And just to scuttle my right, a judgment in one case was relied upon. Not the first and foremost thing, there was no document placed before the tribunal to demonstrate that screening committee in fact applied the mind with the material which I have placed. Nothing was placed. Simply on affidavit, they have said so. And Lordship, based on no evidence, the tribunal came to the same finding, saying no, nothing doing. Since it has been turned on by the expert body, we cannot accede your prayer. This is first ground. Secondly, a case of one, I'll just show that, my lord, where the tribunal went wrong. At page 6, one Shiny Joe's case was taken into account by the tribunal. At page 6 of the impugned judgment. At the top, my lord would find.
Yes.
In the said meeting, the case of one of the candidates, namely Miss Shiny GHOSH was also kind of rejected along with that of the applicant. The committee had recorded its finding in case of both the claimants that there was no immediate economic distress warranting appointment on compassionate ground. Being agreed with the said Ms. Shiny GHOSH had approached this tribunal by way of filing OA number so the OA came to be dismissed by taking into consideration the facts that the case of the applicant therein was placed before this screening committee on several occasions, and the minutes of the said meetings amply demonstrated that her case was considered with the due diligence and that no useful purpose would be served by granting the relief sought by the applicant hearing. Lordship, this consideration was made by the tribunal to turn down my claim. Lordship, my case was not based on this. I'm not in the similarly situated situation, Lordship. My case is altogether different. There,
There was no
Lordship,
earning member in your family?
nobody. In Shiny GHOSH case, Lordship, there was earning member. The screening committee had an occasion to deal with it. On decision of an appropriate meeting, Lordship, it held that Shiny GHOSH case may not be considered. But the tribunal, in order to discard my claim, has applied this judgment. So mainly on these two grounds, Lord, I say, Lordship, the tribunal went wrong. And Lord, as I've said, Lordship, the compassionate.
No evidence was put forward before the tribunal?
Nothing.
Oral order?
Nothing, Lord, nothing, Lord. Lordship, once they complete their argument, I will place I have no right to place the judgment even on compassionate ground, but there are some exceptions being carved out. The court can enter into the domain. I will place it tomorrow, provided they complete their argument.
Tomorrow?
Not tomorrow, but my lord, subject to whatever my senior has said, one thing, this is definitely a compassionate ground, but there are 58 members who have applied in similarly placed circumstances. There are only home guards left at that time. 3 vacancies were there, 3 were selected, depending upon the circumstances and their family position and their wealth, whatever it may be.
Where are those details taken
The
into
screening
consideration?
committee, the CAT has recorded in its order, and we have also been informed the screening committee just rejected the applicant's prayer because his family had the will to carry on.
Where is
They
the
are
document?
receiving the pensions and all.
Where is the evidence? Where is the document that the family
And
had the?
In affidavit in
means to
opposition,
carry
they
on?
have provided, otherwise I will also check it up and I will take the instructions from the department. Whether I will also
It
take the
cannot be
instruction whether
based on
right now
conjecture
there
and
is any.
surmise, isn't it?
Yes,
It should be based on some document
my lord,
or rather evidence.
my lord,
So please come back tomorrow.
my lord.
Third learned counsel for the appellant. Paragraph on prayer of the respondents, the matter is adjourned. Paragraph that the matter appear under the same heading. Tomorrow, that is on, give tomorrow's date, okay?
Obliged.
I pay for the respondent, my lord.
Yes,
As per the direction, we have filed the supplementary report regarding holding circuit of the cat. And we submit that this application has become infructuous as non-patentable and it has to be dismissed. Because holding of circuit is as per the pendency of the cases, and there are 5 circuits cat is holding. And apart from that, every Thursday video conferencing is also held. So,
let us hear the matter from
my lord.
Unit Counsel.
Here, this tribunal, there is a circuit bench of the Central Administrative Tribunal at Fort Blair. My lord, from last more than 8 years, it was not properly functioning. Only in a year, on 2 occasions, such circuit comes for 7 days or 14 days, my lord. Therefore, I taken out this writ petition.
Twice a year,
my lord, for 7 days I have specifically stated, my lord, from last more than 8 years. So very purpose is defeated. Here, most of the people are government servant, and many occasion, because of the distance and the other difficulties which they are facing, they accept the illegal order of the government. Now, my lord, for that purpose, initially we filed a representation before the authorities, followed by filing of this public interest litigation. Once I took out this, thereafter, my lord, they started coming at 4 times in a year, my lord. Only after filing this. Now, my lord, after this, they have filed an affidavit whereby they said that in a year we will come only for 4 circuit. And my lord, kindly come to their supplementary affidavit once, my lord, which was filed on. Kindly come to their supplementary affidavit, my lord, where they say this in terms of the direction of this court dated for 24th of April 2023. Got it, my lord? At the top itself, my lord, they say supplementary report.
Yes.
Got it, my lord? Kindly come to para 2.3.
Oh, sir, yes.
They say, my lord, at the CAT Calcutta bench, there are 4 sanction posts of members comprising of 2 judicial member and 2 administrative member. Out of this, 3 posts has already been filled up, including 1 judicial and 2 administrative members. Now, my lord, kindly come to page para 2.7, my lord. Got it, my lord?
Yes.
It says, my lord, further, as far as possibility of increasing of number of extension of circuit bench at Port Blair is concerned, it is submitted that it can be considered once the appointment of 2nd judicial member at Calcutta is done. The remaining 2 schedule comprise so and so. Now, my lord, the ground which has been agitated in this supplementary affidavit that once the judicial member joins, thereafter we will increase. Now they say, my lord, in para 2.5, presently there are 5 circuits. Got it, my lord? Para 2.5. So they say once the judicial member join, we will increase it. Now the judicial member has joined on 25th of September 2023. So, my lord, on the earlier occasion also they have said that 5 circuit we are agreeable. Now I say, my lord, it ought to be, because my prayer was every successive month. I am not harping upon that. I say, my lord, at least there must be 6 circuits in a year. And they themselves agreed at para 2.7 that the moment judicial officer take over the charge, we will increase it. So let them increase it to 6. Now they are saying 5.
5 circuits are in place at the moment.
At the moment, only after I file my representation, followed by this application.
And the virtual hearing is also there for specifically.
Everything, my lord, after this case and this, everything, my lord.
No,
Virtual hearings, how many days a week?
one day, Thursday, every Thursday.
Every Thursday.
Sir.
Yes, my lord, it is there.
Don't you think that should suffice?
My lord, 6 circuit, my lord, they themselves says at 2.7 that once the judicial member take over the charge, we will increase it. I am asking only 1 increase because they say 5 circuit. I say that after he has joined, you do at least 6 circuits. And my lord, most importantly, it should not clash with the calendar of the High Court, my lord. Last occasion, what happened, my lord?
Both were together, both the circuits.
Yes,
were
my lord, it
together.
was overlapping, my lord. We are the set of advocates who are practicing here and the tribunal, my lord.
Fine.
So we are facing difficulty on that. So
For
this
that,
is what, my lord,
before fixing the calendar, we used to send to the bar association. On the consent of the bar association, this has been fixed.
No, it can't be because it's overlapping.
No, a circuit is generally fixed on consent of the bar.
Yes.
No, my lord, this circuit, this our High Court circuit, my lord, we get the list even in the month of December or January for the next year. So the moment this list come, they also get the said list. According to that only they have to fix the
No,
circuit.
It is fixed only on your consent, sir. So if you.
My lord, at no point of time we have given our consent, my lord.
Your prayer is for every successive one.
But now, my lord, I am confining it. They say 5 and they say 2.7. Once increase, we will increase it. So let it be 6.
So let the petition be disposed of,
lord.
requesting the authority to consider.
My lord,
No, my lord, on the basis of their own statement at 2.5, they say that 5 circuit, it is already there, 2.5.
yes,
In September, the other judicial member has been appointed.
On
right?
25th of
Yes.
September, my lord.
So now, will you consider increasing another circuit
My lord.
in terms of your supplementary affidavit?
my lord, based on the,
Please come to 2.7,
My lord.
supplementary affidavit.
it can be considered once the appointment of judicial member
Yes,
is
sir.
done.
Has been done,
My
right?
lord, yes, my lord.
So, can you increase one more circuit? Will you consider this and come back, maybe a couple of days,
My lord.
later? Because I understand you need to take instructions. on
My
this.
lord.
You cannot make. give
Yes,
an
my lord.
opinion. Yes.
Yes, ma'am.
So will you come back on Friday?
My lord,
My lord.
Let him come back
My
with instructions on Friday, right?
my lord, let it be on Monday, my lord.
Next Monday, very good.
Monday.
So it can be disposed of.
My lord, this can be disposed of.
The present public interest litigation has been filed seeking
Hmm.
holding of circuit bench of the Central Administrative Tribunal, Kolkata bench, at Port Blair for successive, in every successive month in every alternate month for expeditious disposal of cases. Right. Placing reliance on the supplementary report submitted on behalf of the respondents, learned counsel for the respondents submits that since the second judicial member of the Kolkata bench has been appointed in September
Yes, Madam.
2023, further instructions are required as to increase in number of sitting of the circuit bench in Port Blair. Stop. Paragraph, the supplementary report spells out that at present, the circuit bench is held on 5 occasions and matters are taken up through video conferencing every Thursday. Stop. Paragraph, learned counsel for the petitioner insists on increase of the circuit bench to 6. Paragraph, let the matter appear under the same heading on 16 October in order to facilitate learned counsel for the respondents to take necessary instructions in this regard.
Obliged, my lord.
Obliged.
Increase of 1 more.
My lord.
Please consider and come.
I shall, my lord.
In terms of your undertakings.
My lord.
Obliged.
Obliged, my lord.
হ্যাঁ, শোনা যাবে না। তার মাঝখানে উনি আবার call করছেন। একা একা ইয়ে করছে, লাইট করছে। মানে এই পজিশনে যাচ্ছে না, ক্যামেরা আপনার ওই পজিশন।
এটাই এটাই
হ্যাঁ, এটা দিয়ে দাও। লাইভ স্ট্রিম আপনি ভিডিও অন করেছেন, তো লাইভ স্ট্রিম আপনাকেই দেখাচ্ছে। हेलो। हाँ, कब स्टार्ट होंगे? और ठीक है, हम लोग ऑनलाइन बैठे लॉग इन कर। अच्छा ठीक है। আচ্ছা আচ্ছা, দুটো কথা বললো। একটা বললো 11:45-এ বসবে, আর সেকেন্ড বললেন যে স্যাটারডে, মানে এখান থেকে নাকি কপি যেতে স্যাটারডে হয়ে যাবে। তো ওরা কপি নিয়ে রেডি আছে, যদি আপনি মেনশন করে বলে দেন যে মানে কপিটা দিয়ে আর কি। হ্যাঁ, স্যাটারডে দিনে লেট হয়ে যাবে, আমরা কপি নিয়ে রেডি আছি। একবারও দেখেছি।
From the list, man.
May I permit to mentioning one of the one matter?
Please.
Yes.
Yes,
My lord, I just believe this matter has not been listed in the circuit. Mentioning. Let it appear to me.
why to be mentioned? What is the matter?
This there was a direction for affidavit, which direction was there,
Affidavits have not been completed.
and direction was there, they have not filed yet. Let it come tomorrow, so that let them clarify their status. Obliged.
Any other mentioning?
No, from the list,
I'll call the list. Yes, he
My
mentioned.
lord, yes, my lord, may I permit to mentioning one very urgent matter, my lord? The matter petitioners are working since 2020 in my lord in Port Blair, my lord, ANIIMs. My lord, the authorities are going to record the my lord, the persons by deprive the petitioners. My lord, they all at the contractual agreement, the time to time extended. Well, I filed the matter before the principal bench on the last occasion, my lord, the Friday. Justice Lopita Banerjee was pleased to release and send back the matter to my lord, the Port Blair bench, my lord. So, my lord, kindly listed the matter, my lord, very urgent matter, my lord, petitioner present there. But if the matter was not placed before the this bench, my lord, kindly take up the matter, my lord. This is kind consideration, my lord.
The
They have
number,
to take up.
please provide the number.
Yes, my lord, the WPA number 959 of 2023.
It will be listed.
But kindly take it because that they are going to recruit Malati by deprive the petitioner. That is the urgency, my lord.
Yes,
Kindly
please.
take it to tomorrow or day after tomorrow, my lord.
Day after, the file has to come. Yes, so Friday? Friday,
Yes, my lord. Get.
file has to come.
I had to get to.
My lord, I pray leave to mention from the list, my lord.
I'll call the list. I'll call the list.
My lord.
Not from the list. Let me call the list. Yes, any other e-mentioning? No, please call the list.
Well, this matter I am paying for not today. I have not given the short statement of Binu Kumar. He is for the.
It's a new motion.
So it should be fixed for hearing, my lord, because affidavits are complete in this matter.
Affidavits are complete. You filed your reply.
But I filed my affidavit in opposition, you have filed it.
The replies are, who is appearing for the appellant? The
Binu,
petitioner.
Mr. Binu Kumar is appearing for the.
So let it appear under the heading hearing. On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the heading hearing. On when will you come back?
But he has requested me to get it fixed tomorrow.
When will it take tomorrow? 11th.
And three, along with two other matters are become looking. At my instance, those two matters will be delisted. So that these two matters be taken up tomorrow, all the courts can be decided by this, just to avoid conflicting concern.
I'll just make it not today in that case.
Well,
2 and 3,
yes.
not today.
Yes, my lords. Problems.
Item of WPA 946 of 2023.
In this, my lord, I am for the petitioner.
Yes.
I have served the.
The respondents have received their copy.
Lordship, I appear for the private respondent. I would like to use my affidavit in opposition.
My
to
lord,
this.
this can be disposed of. My lord, may kindly see my prayer. The private respondent, they have encroached the government part, as well as they have encroached my
Affidavit of
land.
opposition is not required in this matter.
Lordship, I need to refute the allegations leveled against
My lord,
me.
I have enclosed entire document wherein
No,
the
it
report of the
comes-
Tahsildar is there.
That I will not be given an
I
opportunity to
pray,
file
my
an
lord.
affidavit.
What I pray, my lord, the revenue case was initiated by the Tahsildar Paharganj. After that, a demarcation was conducted wherein the report reveals that he has encroached the government revenue land, a footpath, as well as my land, private land. I only pray, my lord, that as per the judgment of the Honorable Apex Court, that nobody can encroach the government path. And my lord, apart from that, this area for path was surrendered by me. It is my recorded land.
And then a representation before the authority?
Revenue case was initiated, my lord, and after the demarcation was conducted, it reveals that the private respondent encroached my.
So the revenue case is still pending.
I want a direction upon the Tahsildar.
So let her-
Entire exercise has been done without giving me any opportunity of hearing.
Let the
And
opportunity
this
be
case
given to.
has also been passed
This court will not go into merits of the case. Let the authority decide the
Yes.
matter upon giving you an opportunity of.
My
hearing.
lord,
Lordship, the allegations what has been leveled, that has to be deemed to be denied because
I will do that.
will create a problem
I
there.
will record that.
my lord,
Without
This court-
Allegations.
Without going into questions, without going into merits.
my allegation.
Let the authority decide, you'll have your scope before this court after that.
Let that be recorded. I was not given an opportunity to file affidavit.
Allegation only comes when the revenue took a demarcation and they filed a report in the RC case number, revenue case, and after that they did not take any step to evict the private respondent.
Behind my back, the order has been obtained. No opportunity of hearing was given to me and they said that this.
There is no order. There is no order as on date. If there is an order, I could have challenged that before the
This-
revenue authority appeal court. The revenue Tahsildar has not initiated
I don't
anything after that.
direct disposal of the revenue case
My lord,
without going into merits.
My
right?
lord,
Lordship, ample opportunity to be given.
Absolutely,
Yes.
absolutely. You're entitled to it.
Yes.
Absolutely.
my lord.
Heard learned counsels for the parties. Paragraph, it is submitted on behalf of the petitioner that alleging encroachment of government land by the
Private
private
respondent,
respondent
my lord.
comma, the petitioner approached the
Tahsildar for
Tehsildar Ferarganj Tehsil,
who is the respondent number 2.
comma, the second respondent herein, who, comma, upon a report being submitted,
Passed an order of stay, which is page number 19.
submitted by whom?
Tahsildar Patwari, my lord, area concern Patwari, which is page number 21.
And the case started in page number 30.
Page number 19, my lord, the stay order was passed and thereafter no further action was taken by the Tahsildar. Page number 19 of my writ petition.
Who upon receipt of a report submitted by the concerned Tehsildar upon Tehsildar
Patwari,
upon demarcation of the plot in question, comma,
Report of the Patwari, not
Patwari, area
Tahsildar.
Patwari, was demarcated.
area Patwari. Initiated
Revenue case number 119 of
where is
2020.
that document?
19, my lord, page number 19, he has passed an order of stay.
Initiated revenue case number 119 of 2023 and directed stoppage of all ongoing construction activities upon the subject land and vacating the government land. Stop. Paragraph. Learned counsel for the petitioner submits that no further step has been taken by the authority since then, and the revenue case is still pending. Paragraph. Learned counsel for the private respondent submits that no opportunity of hearing was granted to the respondent at the time of survey of the plot in question. Paragraph. Learned counsel for respondent numbers 1 and 2 submits that the second respondent be directed to dispose of the matter in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to dispose of the case being RC number 119 of 2023 within 1 month,
2 months, my lord, because.
2 months. Why
2
4
months.
months?
Why?
Because there is a holiday for it, where I found next week.
Holiday is only for 2 days, my lord. It's not here for 10 days or a week,
Very well, 3 months.
my lord.
Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the private respondent, comma, in accordance with law. Paragraph. It is made clear that this court has not gone into the merits of the case, and the authority shall be at liberty to deal with the case on merits without being influenced by any observation which may have been made in this order. Paragraph. The writ petition being WPA such and such is accordingly disposed of. There shall, however, be no orders to costs, since no affidavit is invited, comma, the allegations made in the writ petition are deemed not to have been admitted. Paragraph. Urgent certified, etc.
Oblige, my lord.
Yeah, I'm appearing for the petitioner, my lord. My lord, here, the petitioner, she has purchased the land in the year 1984. Last 40.
There are other respondents also,
Private respondent,
I'm appearing for official respondent.
Yeah. and she is appearing for the private respondent.
so all of them are there.
My lord.
Yes.
My lord, thereafter, my lord, several notices were given for demarcation. On some occasions, demarcation was conducted also, but under the Right to Information Act, the petitioner has asked for report of the demarcation. They are not provided with. Lastly, the demarcation was done. It's at page, my lord, page 60 is the last notice. Notice was given dated 17th May 2023, Annexure P18, my lord. Here, the date was fixed on 25/5/2023. Thereafter, my lord, kindly
You are alleging unauthorized occupation.
the other side has the private respondent. They have encroached my land. They have encroached my land. Recently, they have purchased the land and they have encroached my land.
They have encroached your private land.
My lord.
So how is the writ petition maintainable?
My lord, thereafter, my lord, there is a dispute. So I have paid for demarcation. Demarcation is the authority is the Tahsildar. He can demarcate it under the local regulation. My lord. So kindly come to page 62, my lord. There's a vacation order. There was a stay order. Thereafter, my lord, the vacation order. In the vacation order, it is mentioned, my lord, from paragraph 4. Whereas in this matter, demarcation was conducted on 8/12/2020, 17/8/2021, and 22/6/2022 by the revenue surveyors of the Rangat Tahsil. But one of the above party has disagreed with every demarcation carried out. Thereafter, my lord, and whereas after obtaining approval from the Deputy Commissioner, North and Middle Andaman, the revenue survey Mayabandar in presence of SND Mayabandar Tahsil conducted demarcation on 28/5/2023. Despite of that, the parties have again disagreed with the demarcation report. Thereafter, my lord, and whereas ample opportunity was provided to both the parties on the audio, they are saying that the opportunity was given and the demarcation was done on 28/5. It is mistakenly it is written because the last notice was received on 25/5/2023 was the date fixed. My lord, thereafter 63 kindly come, my lord. They have concluded with the direction to construct the house by the private respondent, because the private respondent is working in the revenue department. She is working in the revenue department. So for that reason only all these things happen here, my lord. 63 kindly come, my lord. Last, subject to the extent of present print, directed the both the parties, Srimati Baby Mandal and Srimati Pushpavali, that is the petitioner herein, will not erect any boundary until further direction. This was passed on 14th August 2023, my lord. Thereafter, kindly come to, my lord, page 68, my lord. Once, my lord.
Yes.
Under the Right to Information Act, I asked certain questions, my lord. In the reply, kindly come to next reply, my lord. Second, according to the available information, available documents has not demarcation was not conducted on 25/5/2023. My lord, the Tahsildar is the authority. He has not conducted on 25/5/2023 the demarcation, but the settlement officer has come to the conclusion that on the particular date the demarcation was conducted and there is a direction to stop the not to erect any boundaries. So what I pray, my lord, let a demarcation, fresh demarcation may be conducted in presence of both the parties. Fresh demarcation. Because the dispute started from 2020, my lord. From 2020. My client, she is 73 years old, my lord. From since 1984, she was not having any problem, any dispute. From 2020, only the dispute came because of this private respondent, my lord. Because she is working in the revenue department.
The RTI reply says that there was no demarcation on 25th.
25th.
But the vacation order
Only
demarcation on 28th.
that is a typical because typographical error, my lord. Because why I say, because the notice was given, the date was fixed on 25th.
Demarcation was not in presence of any of the parties.
No, no.
Let us hear the red.
And the no report has supplied, my lord. If the demarcation has conducted, the report has to be given to the petitioner.
Absolutely.
That was
Let the revenue respond. Yes.
my lord.
No, what the record speaks, I have to go with that because. I thought that
Absolutely.
They have demarcated and.
Was the demarcation in presence of both the parties? There is no reflection.
That is, that I have to accept.
So let there be a fresh demarcation in presence of both the parties.
Lordship.
Anything to add,
Yes,
sir?
yes, Lordship. Kindly come to page 65, Lordship,
Yes.
for a second. This is the real grievance of the writ petitioner. Now, in the grievance, they say prayer for settlement of boundary dispute. And now, as per the averment which they are making before this honorable court, they want to stop the construction. So moreover, this fight is a form of an ego fight, Your Honor. And about the demarcation, I will just show one document. Kindly come to page 29, Lordship. Page 29, demarcation has been conducted on 3 occasions.
All of them in presence of the parties?
Yes, yes, on 3 occasions, Lordship. But from on twice, the other side have made the objection that they are not satisfied with the demarcation report. And once it was from the side of the private respondent that she is not satisfied with the demarcation report. So it's not the case that demarcation has not been conducted. It has been conducted on 3 occasions. Now this page number 29 will show this, Lordship, paragraph 2. The demarcation was carried out on 7/8/2021. This is what they have, it is their acceptance. By the revenue surveyor, as per the notice, I was not satisfied with the demarcation. So
After that, there was a further demarcation.
there was a demarcation, Lordship. But the thing is, the revenue authority have waited 8 months. They have given notice to the other side on 3 occasions. And all the 3 occasions, they have shown that due to the old age, the writ petitioner cannot appear before the demarcation. So it's not the authority, Lordship. So on 3 occasions, the notice has been issued. That is on record. But they have not appeared. And then they have given a reply to the assistant commissioner that kindly evict the stay order. So they are more towards evicting the stay order so that construction may be stopped rather than settling the dispute, Lordship. So this is my humble submission. Apart from that, Lordship, one more submission. As per their averment, the writ petition is a power of attorney holder for the mother. But they have not shown any document here which shows that she has given the power. Why I'm highlighting this thing? Because the brother has already filed a civil suit in the other court, asking the claim from the mother and the sister.
Some other brother.
Some other brother.
the brother, the son of the writ petitioner. The brother of the writ petitioner, rather. So these things has to be seen, Your Honor, whether the lucus standi is there or not.
And the authority has not been able to explain this dichotomy. At page 68, they say there has been no demarcation. And page 62 says there has been a demarcation.
Lordship, there is a
But there is no-
correction of the date. One says 25, one says that 28. Maybe the demarcation has taken place because they have not appeared on 3 occasions. And due to that, I could not carry my construction, Lordship, from last 1 year.
I've given the reason stating that I am in Port Blair because the property belongs to Rangat. It's a different area.
Yes,
madam.
yes.
So because she is 73 years old, she had some problem, my lord.
So let her
Medical
authorized
issues.
representative be there. If she is not able, let her authorized representative.
Yes.
be there.
That has given, that letter has been given.
Was her authorized representative present?
My lord, today she is not present, madam.
No, when the demarcation was made.
No, my lord, because she has paid for adjournment on the particular day.
Where is that prayer?
Earlier.
My lord, it is there, my lord. That also I have next.
We are not hiding from the demarcation, Lordship, because it should be clear, because our boundary is also involved. But in the garb of that, some other thing should not be hit, Your Lordship, because I am doing my lawful construction.
Let me see if there has been a notice and a reply.
My lord, it's
Then there is no question of a fresh demarcation.
my lord, it's at page 44, my lord.
Page 44.
My lord, request to postpone, keep pending the demarcation which is scheduled to be conducted on 29/2022 as per the notice issued by the, that is there, my lord, once.
No, with regard to the last demarcation, 25th.
25th, though,
This is in 2022.
my lord, though notice was issued, but the demarcation was not conducted.
Your
Because I have prayed for, I'm asking the demarcation report at least. They have to give me the demarcation report.
Lordship, these are factual aspects. It has to come, I should be given other opportunity to file
My
affidavit.
lord, I am praying only for demarcation. Only for demarcation. The demarcation has to be under local regulation, my lord. 101 is very clear, my lord. 101 is very clear, my lord. With regard to demarcation, boundary dispute, if any boundary disputes are there, let them demarcate it, let them give the
Because
report,
there
my
is
lord.
some dichotomy. 25th, 28th, it cannot be, this cannot be
I've seen
explained.
this.
Cannot
There
be
is a,
explained.
there is a,
So
error in the
let's
date.
a fresh demarcation.
Lordship,
Some-
Lordship,
Start on-
Lordship.
I am saying it's not only, my lord.
Lordship.
My lord.
And if the petitioner is unable to attend, let her authorized representative.
Lordship,
My lord.
And
Lordship.
there is the power of attorney who
Yes.
represents the petitioner here. One of the sons is representing, isn't it?
No, one of the daughter is representing her. And the son has filed a civil suit.
Yes. I do not find the power of
There is no
attorney.
power of attorney.
It is there, my lord.
Page.
My lord, I have not annexed with the writ petition, my lord. I have not annexed with the writ petition, but I am having, my lord. I
Your
supply
Honor,
the copy, my lord. I supply the copy,
Please show me the power of attorney. Should have been annexed, isn't it?
my lord.
It's on the basis of that.
My lord, my lord. Lord, this is the. This is actually a part of the minute. Petitioner is the Pushpavalli, my lord. She has given power to her daughter Kannagi, who is affirmed this writ petition, my lord. On the second page, it is mentioned, my lord, all court matters, everything, my lord.
Will you come back with a supplementary affidavit annexing this document because it
I'll
has
do
to
it.
remain on
I'll
record?
do it, my lord.
I'll just make it not today.
My lord,
Lordship.
Can you come back tomorrow?
my lord, my
Lordship.
lord. I'll do it, my lord.
Please give this back. Only not today.
grapefruit.
Obliged, my lord.
I appear for the respondent.
Petitioner,
My lord, your
Mr.
petitioner has some personal difficulty, my lord. He has undergone surgery,
yes.
so he will not be available in this circuit.
So you want to come back in the next circuit?
My lord.
Yesterday also somebody submitted.
Learned counsel for the petitioner submits. The petitioner has undergone surgery.
My lord.
But it says counsel.
Counsel for
Counsel.
Counsel.
Yes.
Not this. We are informed that learned counsel for the petitioner has undergone surgery and shall not be available in this circuit bench. Paragraph, the matter be placed before the next available circuit bench.
Obliged, my lord.
WP 884 of 2023.
My lord, in this matter, my senior Mohammed Tabil is appearing for the writ petitioner, my lord. My lord, due to some medical emergency, my lord, my senior is left to mainland for some medical treatment of his wife. So I pray for the matter can be pay for next circuit. Next circuit.
Next week he'll not be available.
Not. My lord, in the meantime, the report may be supplying. The report has been.
You are appearing for the respondent.
Oh, yes, sir. Report has been filed.
The report has been filed. Filed today.
No longer.
The report long back. It has been filed long back.
In the last circuit, the report has been filed, but the
You
copy.
received a copy, no?
No.
Please, sir.
There was no direction for issuing copy.
They're saying that no direction has been.
Separate direction is not necessary. Whatever you file in court, the other side is entitled to a copy, isn't it? Please serve a copy.
If my lord pass on.
It is submitted on behalf of the petitioner that the report submitted, that a copy of the report submitted by the state in court has not been made over to him. Paragraph, learned counsel for the state is requested to make over a copy of the report to the petitioner / his learned counsel at the earliest. Paragraph, this court is informed that learned counsel for the petitioner was constrained to leave the station due to medical emergency and may not be available in the present circuit. Paragraph, in view of the above, comma, let the matter be placed before the next available circuit bench. Don't use the word let, the matter be placed.
Of like.
Item 8, WP 889 of 2023.
I'm praying for not today. Otherwise, I think affidavit.
For the petition.
If all the matters are not today, how? Give me
The no
the.
affidavit in reply, if my learned friend is saying, then there's a problem there. This matter is one where they were to file an affidavit in opposition, I was to file a reply. But if your lordship sees the opposition, I find it, I cannot understand the practice of making a affidavit disclosing some sort of a prayer. If he wants, he has to take on an application.
Absolutely.
Now, what they have said in their reply, essentially, I'll tell you, lordship, what this matter is. This petitioner is a contractor. He had to conduct certain work of building certain Anganwadi centers throughout North and Middle and West. Admittedly, he had the contract. Admittedly, he's done the work. Admittedly, completion certificate is issued, bills are done, everything's done. But for the last 2.5 years, he's not getting his payments. Now, those payments were pending. He made representations to the administration, chief secretary, lieutenant governor, everyone. My lord, he has been informed by certain parts of the administration that the money is missing. Now, these contracts are what are called deposit contracts. The money is already allocated for this. They do the work, the money is disbursed. On this basis, we came up before this court saying that let the matter be considered by the authorities for disbursal of the amounts, because it's not in dispute that the work is done. And let it be disbursed.
Yes.
Now, at this point of time, the state said we want to file an opposition. Now, they filed an opposition where they've said 2 or 3 very peculiar things. First of all, the APWD is a party. So we have made the chief engineer a respondent. Now, they have filed an affidavit through an executive engineer who is a subordinate to the chief engineer, who says, I am not a party, I should be made a party. Now, if he wants to implead himself.
This is stated in the opposition.
In the opposition, if he wants to implead himself, he has to take on an application.
Absolutely.
Number one. Number two, they have raised a factual issue saying that, yes, you've done the work. Yes, we want to pay you. But the problem is that the government of India is not sending us the money. So you make Government of India Ministry of Minority Affairs a party. I don't understand. You can't make that prayer. And the third thing, which is even more ironic, is they say that there's another contractor in the same situation, work completed, bills raised, 2 years bills are pending, but money is not being released to him.
How is it relevant?
It's not. Well, they are saying that he has also come before this court. He has filed some case. Therefore, what order has been passed there, it will have to be passed. You know, on one hand, they say my writ is not maintainable. On the other hand, they say add me as a party. He's not a party. How he files an affidavit, I don't understand. So in this background, for me to file a reply is
The
an
affidavit
academic
is on behalf
proposition.
of respondent numbers 4 and 6.
The APWD.
Yes.
Now APWD, we have made the chief engineer a party. It is for him to answer. An executive engineer now files an affidavit saying I must be added in as a party. Then you take out an application for implement of
Executive
parties.
engineer should be on behalf of.
On behalf of, exactly.
4 and 6.
I'm grateful.
And that is what is recorded in the affidavit itself, that it's on behalf of 4 and 6.
But kindly see the content of it. And beyond that, he has not dealt with merits. Now, what am I to reply to?
Is there any question of merits at all?
No, that is the whole point.
Yeah, the ministry has to be made party. Kindly see page number 32, which is the similar order, in a similar matter where Honorable Justice Rajshekar Mantha has passed an order. Our problem is that the funds are exhausted and ministry supplies us the funds.
How are the funds exhausted which were provided for this particular purpose?
That funds
Whose
are
responsibility is it?
funds exhausted because from time to time ministry send us some amounts of funds. There are a lot of contractors
Deposit contracts.
working upon the similar projects. The funds are right now exhausted. Well, that's why we have made a prayer that ministry must be made party to this matter. So this
It is between you and the
My
ministry.
lord, I'm very
interface, sir.
grateful.
ministry over here is a separate. So in this way, kindly, that's why I'm praying
Admittedly,
for.
the work has been completed and you need to pay. There cannot be any other option.
So let me,
there's another-
Please arrange for the payment.
let me come with the instruction. Let this go not today, because tomorrow my senior will also be available.
Not today, come back
Well,
tomorrow.
there's another angle. This petitioner, and this is on record, I'm not making submissions out of record, is in the last stages of cancer. He is very severely ill. He has no money because he has put all his funds into this. His company has gone belly up because he has spent all his money on these works. My lord, even now I am instructed that
Do
he
you
has
wish
gone to the
use a
mainland.
reply to the
No,
evidence?
there's no point,
No
but
point,
this can be
no
disposed of, my lord. I would pray for that because this man needs
Please
that
come back tomorrow.
financial.
It
This,
will be disposed of
my
tomorrow.
lord, I'm ready.
Come back,
Deep.
not today. Please take instructions. You have to pay, now please decide how you will pay.
Now,
That's
the
absolutely
difficulty
up to you.
will also come that if your lordship will pass an order, then we don't have fund, we're going to write the ministry, then ministry is not.
These are deposit contracts. There is no question of no funds.
We have done our part, we have written to ministry what we can do. So that's why we are asking for.
That's a communication, that's an interdepartmental
But
communication.
here are certain problems are there, that's why.
I know there are technical issues in the administration, I am aware of it,
My lord,
but then the writ court will not deal with it.
my lord. Let us.
You have taken the work, you have to arrange for funds. Next,
Great.
Item 76, item 10, WPA 904 of 2023.
I wait for the respondent, my lord.
petitioner,
Respondent number 1213 only.
yes,
For court number 2, my short password.
well, passed over.
Item 11, WPA 905 of 2023.
11 and 12, my lord, I am praying not to them, my lord.
All matters cannot be made not to.
But-
Please make your
Well,
submission.
just a course of, my lord, just a course of day, my lord. One day, my lord, one day.
Let it be tomorrow.
You are the petitioner?
I'm for the such thing is appearing. He is also returning today from Kolkata. So let it be taken up tomorrow.
Very well, 11 and 12 both, not today.
Item 13, WPA.
Please be ready tomorrow.
My lord,
Item 13, WPA 905.
My lord, I am appealing for the respondent.
Petitioner?
I am for the petition.
Yes.
My lord, I was under the impression that the service is incomplete.
That the
The service is incomplete.
service is completed.
He says, no, it is complete.
No, I am.
It's received it.
My lord,
Yes.
Labour-
So you are appearing, yes.
I am
Yes,
appealing.
you did.
Labour court has passed an award in favor of the workman.
Let it-
challenge.
My lord, it is there, my lord. I was under the impression that it's not incomplete.
So you're not ready today?
No, it's not.
When do you want to come back?
Monday, my lord.
Why don't you come back on Thursday?
But a lot of matters.
Monday we'll have. only
A
3
lot
more
of
days.
matters of my lord has fixed on that day.
So Friday,
That will be
because next week we have 4 working days. So why not do it within this week itself?
Only 4 working days. no?
Next week. 19th is the
it's-
last, next week,
yes,
next week.
it's there, my
19th
lord.
is the last working day.
It's there. my-
So it's better that we deal with it this week itself.
If that pleases my lord on Monday,
Yes,
my lord pleases for Monday,
Monday.
Monday. If not,
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same
Deep.
heading on 16th.
if
I pay for the respondent bank, my lord. There are private respondent, there is direction to the
Have you
petitioner.
served? Who is appearing for the petitioner?
Mr. Sabir.
No one. Petitioner? You are appearing for the bank.
My lord.
There are a lot of private respondents.
Yes, my lord.
None appears for the petitioner. Stop, no accommodation is sought. Paragraph, let the matter. Is it a short matter?
No, my lord, it is a similar matters. It has to be filed by affidavit,
Come back on Monday.
my lord,
Let the matter appear under the same heading on 16th.
my lord.
My lord, I am appearing for the petitioner.
But I am for the respondent, my lord, against this matter, my lord, actually what has happened that it should be a contempt matter, but since 1 year has elapsed, they have filed a writ petition for effecting an order. But we have made an
That can be
appeal.
done. There is no.
Yes,
problem.
we have made, that can be done. We have made an appeal, my lord. Your lordship has yesterday passed an order. Appeal is on next week, my lord, fixed on next week. The copies are not been served, my lord. We have, I have directed, requested the department to serve the copy.
My lord,
upon
what
the
happened, my lord?
respondents
This
in
order
that
was
appeal.
passed sometime in the month of March 2021. Thereafter, my lord, time to time, we have given letter and all. Subsequently, I have filed a notice whereby I said that we will be filing contempt application. Thereafter also, they did not act. In the meanwhile, it is an autonomous body. A resolution was adopted whereby they said that we are going to implement the judgment. Despite of that, they have not implemented. I filed a writ petition for implementation of the order of this court. They took out an appeal after more than 800 days. Now only I am not on the merit of the appeal. What I am on, my lord, let the copy be served. Last circuit also same submission was advanced. They did not serve the copy of the appeal. And the matter is lingering, and because of which we are unable to get the fruits of the order passed by this
I
court.
will serve the copy, will serve the copy. The directions has already been passed.
By today.
By to actually the copy has to be served upon the party and not upon the.
No, definitely, at least they are working under you.
Decides on the, for distinct areas, my lord. There are lots
No,
of.
no, no, it
parties,
is
my lord.
within Port Blair Municipal Council.
But there are lots of parties.
It's Port Blair Tehsil.
Yeah,
But there are lots of 59 parties are there, my lord.
not 59. No,
Something, there are lots of parties.
15 or
are there.
17. You
15,
serve anyone, they will come to me, we will do
I
the matter.
will do that, my lord.
14.
My lord,
14 petitioners.
I'll do that, my lord.
Please serve in the meantime. When is the
Sir.
appeal? When is the appeal fixed?
My appeal is fixed on next week, my lord, on 16th or 18th, something like that.
So let this go to the next circuit in
My
that
lord,
case,
my lord.
because unless the appeal is disposed of,
My
nothing
lord.
can be done. The petitioners assail the order passed in WP number 106 of 2021 by this court on March 19, 2021. Stop. Paragraph, learned counsel for the. You are appearing for all the respondents?
Respond, all
The
the.
respondents submits that the said order has been carried in appeal before the division bench, and the appeal has been fixed for hearing next week. Paragraph in view of the above, let this matter appear before the next available circuit bench.
My lord.
Item 16, WK 941 of 2022. And therefore the.
I am therefore official respondent. There was direction to serve upon the private respondent.
Affidavit of service has been filed. They have been duly sent.
The affidavit of service,
Yes.
they've been served.
Yes,
Have you checked?
I filed the track report also.
4 and 5, Manorama Barua and Om Prakash. I look into it. Manorama is not served. Recipient Manorama, Om Prakash. Where is the service on Om Prakash?
Its track report is there. Now.
Track report is only Manorama, both the
May I
track
check
reports.
once? Yeah, there are two track reports. No.
Please show it.
Just let me know. There might be some mistake, but it has been submitted. No, kindly see. These are the two track report of different consignment number. The two consignment number,
The
different consignment.
recipient's name is Manorama in both the places.
Not, but it has been
Please show
given.
that to him, the recipient's names.
Yes. Some sort of clarification because, but there are two postal slip showing lordship individually, both
Maybe
of them.
both were sent to Manorama by
No,
mistake.
no, both different, two persons, lordship, both the private respondents. So kindly, just have a look to this slip, postal slip also, it's of. You kindly,
Because this becomes a ground for appeal otherwise.
I
If it's
understand.
not served,
I'll come back in that case, lordship. In that case, I'll come back. Did it come on Friday?
Manorama no issue, Om Prakash
There's a
is
postal slip, Lord, kindly.
068.
I'll serve again, I'll come back on Friday, just to avoid the anomaly, just to.
No, the track report corresponding to the postal receipt is also not there. This is 068. This is 970. 139 and 068.
I'll serve afresh, Monarch. So first, Om Prakash is concerned, I'll serve afresh. Let it come on Monday, Friday.
Friday?
Friday.
Very good. Since service upon the 5th respondent is not complete, comma, let the matter stand over till 13th.
I'm great.
WK 942 of 2022.
17 is I am appearing for the bank, same matter as item number 14, my lord. It is fixed,
Petitioner is not there.
not there. That matter is fixed on Monday, so let it be fixed on Monday also.
None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear under the same heading on 16th.
My lord, oblige, my lord.
Item 18, WK 945 of 2022.
But I'm for the writ petition.
I am for the respondent, my lord.
But there are orders of this court as well as of the division bench on the subject issue. But my prayer is, I'm possessing a property which is duly recorded in my name. Under the local regulation, that is Andaman and Nicobar Island Land Revenue and Land Reform Regulation 1966. Regulation 157 is very clear. I can improve my land for the purpose for which it is granted to me. No permission is required. It's embodied, no permissions, and interpreting this provision, this court by my Lord Justice Soumitra Pal, and this order was affirmed, administration took out an appeal. The 157 was interpreted. That while invoking 157, a recorded tenant needs no permission to be obtained, but his or her work has to be confined to 157. What are the categories of work which I can do in terms of 157? The regulation is very clear. So I am seeking the benefit of the order. I am the recorded tenant of the landed property. And now when I started doing the improvement, a prohibition has been made. So I have sought for a writ in the nature of prohibition, that the authorities has to be restrained not to interfere with the improvement which I am liable to do in terms of law. That's it.
Yes,
Well, this application is not maintainable on the two grounds. First, they have never approached the authorities, no representation is there. Thereafter, the petition has been filed by a power of attorney in her individual name. This is very ironic, my lord. Kindly see the record is in the name of some Gauri Shankar. The power of attorney can be representative as a on behalf of the owner, but he cannot become a petitioner
Page
herself.
17 may kindly be seen.
She
Page
cannot
17,
become petitioner
I
herself.
have annexed the power of attorney, deed of power of
Yes,
attorney.
I agree.
I have in the body said
but the
that
cause title has to be.
I'll correct it, Marshal. I'll correct it. I'll correct it. Leave may kindly be granted. Here and now I'll do it.
No,
I'll correct it.
entire cost title you have to change.
No, I have to add them. So leave may kindly be granted.
This is technical. Let the cause
Right.
title be amended.
But
Yes, what is your other point?
my other point is that this is a
No representation has been
no
made.
representation and private disputes are there. They have not added the private respondent. And as such, this application is
Why
not
don't you
maintained.
file a representation before the authority
But
first?
it's a writ of prohibition. It's not a writ of mandamus. But when I started doing improvement work in terms of the regulation, the authorities, more particularly the Tahsildar, interfered with it. And since there are orders of this court, regulation is very clear on this issue. I can place the regulation. If my lord sees the regulation 157, it's very clear.
So 157 has been enumerated
Yes,
here.
And Lord, I'll just place regulation 157. Kindly have a look to page 30, first part of the book, regulation part. 157.
One fifty-seven.
No, no. I'll just place the language. A tenant shall be entitled to make any improvement in his holding for better cultivation of land or its more convenient use. I'm pausing here, Mr. This improvement has been defined. Not kindly see this section. I'll just take section 2, subsection 12 of the regulation. What all I can do it, Mr. under the garb of this improvement. Not got it? 2, regulation
12, yes.
12. Improvement in relation of the holding means any work which materially adds to the value of the holding and which is suitable thereto and consistent with the purpose for which it is held and included. Not the things have been the construction. I can do it construction of tank, wells, water channels, embankment, and other work for storage, supply, or distribution of water for agriculture purpose. The construction of work for drainage of land or for the protection of land from floods or from erosion or other damages. The planting of trees and the reclaiming, cleaning, enclosing, leveling. Even I can do leveling, lordship. Or terracing of land used for agriculture, the erection of buildings on or in the vicinity of the holding elsewhere than Abadi or urban area required for the convenient or preferable use or occupation of the holding, and the renewal or construction of any foregoing works or alteration therein or addition thereto. But I cannot do it, not there as given instance, but
Yes.
does not include these works. So I'm concerned with first 4.
What are you actually wanting to do?
I want to level it, my lordship. I want to use the land for its better cultivation purpose. I want to add the material value, my lordship. Whenever I do it, my lordship, the Tahsildar comes, they interfere.
You
with
have referred to an impugned order. Which is this order?
No, there's nothing in
Your ground says the impugned order is
No,
bad in law.
it's copy paste. No, it has.
Okay.
I'm so sorry. It's the
So
first
there's no
draft.
order.
No, there's no order as such. And the order of this court was affirmed by the division bench also, my lordship. I can place that also. Where the
all right.
improvement has been discussed, the impact of improvement has been discussed. And my lord, kindly see the record entry at page 14. It's a garden land, hilly land. I can do the improvement. So there should not be any attempt on the part of the authority to restrain me. But my work has to be confined to 157, which I'll do. I can raise the building, I can level the land, lordship. These all works are recognized under law, which I can do.
So for raising the house, you have to obtain, convert the land into outside. For that, they have to
Misunderstood. You
obtain,
misunderstood the provision. That means you have
we have to
misunderstood.
apply for permission for diversion of land.
You misunderstood. Under improvement, I can do it, Lord.
So long as he is within the confines of 157, there is no bar.
My lord,
Yes.
my lord.
So let him make improvements strictly in terms of
Yes,
157. Yes.
My lord, for any development, he had to seek obtain prior permission from the.
Where is it stated?
Yes, ma'am. Let them show any rule, regulation that for
Where is it
improvement, I have to
stated?
take permission. Yes, I'm grateful, ma'am.
If he restricts his improvement to 157,
My lord.
does he still have to take permission? Where is it stated?
That,
There's nothing.
there is nothing. That is nothing.
So let him continue in terms of 157 strictly,
My lord,
right?
my lord,
Let it be disposed of.
my lord.
And this order really doesn't help you in this case because here an order was passed that was SL.
Yes, but improvement has been defined and it has been elaborated, Lord. So at page 5.
The rules are very
Well, I
clear.
understand.
The rules are-
I understand.
Let there be an
My
order.
lord. My lord.
Not by the consent of the party, this has to be disposed of. But
No,
tomorrow, what they would do, they would
No,
challenge
no,
you.
no,
That
no.
cannot be
Consent
by
can be
consent. Cannot be. He will not
Just
be-
taking the matter for final disposal. For taking of the matter for final disposal, that has to be considered. Otherwise, what they would do,
No, my
they
lord.
would challenge it. Merit, lordship, they cannot give consent, I know. But
At
for
this-
taking the matter for disposal, final disposal at this juncture, they have to give a consent. lordship.
For that,
Law is-
initial stage, at the start of argument, I prayed that
Both
this
parties
application
are
is
being
not maintained.
represented.
Yes.
Yes.
What is the necessity of consent?
My-
A matter can be taken
my-
up for final disposal since both the
my-
parties are represented.
I'm grateful. Mine.
It's not fixed for under any other heading.
Mine.
I mean, in case of an application or things like that,
Ma'am.
this consent is required,
Ma'am.
isn't it? It's fixed for hearing, I think. Yes, motion.
Motion.
Heard learned counsels for the parties. Paragraph. The writ petitioner seeks a writ of prohibition restraining the respondent authorities from raising any obstruction to development of the plot in question by the petitioner under Rule 157 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation, 1966. Paragraph. The petitioner is representing the recorded tenants of the plot in question who have executed a general power of attorney in her favor in this regard. Stop. On prayer of the petitioner, liberty is granted to amend the cause title of the application in tune with the general power of attorney granted by the tenants. Paragraph. On merits, comma. It is not in dispute that Gauri Shankar Das and Joyanta Das are the recorded tenants in respect of the plot in question. Stop. The tenants intend to develop the plot in terms of Rule 157 of the regulations of 1966. It shall be useful to reproduce Rule 157. The entire rule has to be reproduced. Stop. The term development has been defined. The term improvement within inverted comma, quote unquote, improvement has been defined in Rule 2 within bracket 12 of the rules. Stop. Paragraph. Upon consideration of the submission made on behalf of the before that, just strike out this line. Learned counsel for the respondents their consent cannot be recorded.
My lord, I have challenged him. My submission is that it's not maintainable,
For what? Not maintainable?
but no representation has been made and
That has already been granted.
yes,
And the other learned counsel for the respondent submits that the writ petition is not maintainable for the reason that the petitioner has filed the writ petition in her personal capacity and not as attorney holder of the tenants. Stop. Paragraph. Such amendment having been allowed to be made by the court, comma, the writ petition cannot be discarded on that score. Paragraph. Since the tenants are entitled to make improvement in the tenanted in the holding for better cultivation of the land or its more convenient use in terms of Rule 157, comma, the writ petition is disposed of with liberty to the tenants being represented by the petitioner, comma, to improve the plot in question in strictly in terms of Rule 157 of the rules of 1966. Paragraph. The respondent authorities are restrained from causing any obstruction to such improvement, provided such improvement is done in terms of the rules strictly. That should suffice.
I'm with you.
obliged,
The
my lord.
petition is accordingly disposed of. There shall however be no arrest to costs, since no affidavit and urgent certificate, etc. Those 4 lines will be there always.
Deeply obliged, my lord.
Next.
Item 19, WPA 19,
Madam, I am for the petitioner, madam. But I am for the respondents in this matter. Madam, I am seeking time to file my affidavit in opposition, but this matter requires.
There is an prayer for interim order.
My interim order cannot be granted
And
at
unless
this
this interim order is not granted, the petitioner will suffer irreparable loss.
So what is the matter?
That is the reason. Let me make my submission. My lord, petitioner is a enlisted contractor and he has been working since last 37 years. He's a class 1 contractor. And that last enlistment which was revalidated, that is at page 28.
Have you served all the respondents?
All
There's a private
the
respondent also?
through email I have served and hard copy is sent to his people.
Where is the service?
It is there, every service is on record.
Affidavit of service?
Through mail I have served, that is also there.
The track report is not there.
I mean, mail, through mail also I have served. That is delivered.
Service through mail, there should be a physical service also. Every person is not as savvy as maybe as you are.
I just want, my lord, to just hear me.
Why don't you serve and come back?
If I can satisfy my lord.
A private respondent is a necessary party for.
Why don't you serve and come back,
My
sir?
prayer is innocuous prayer. There will be a loss of public exchequer 2.32 crore.
No, it will be
They are-
considered.
They are,
Why don't you serve and come back?
But the tender is given.
because the party is in Chennai. And they have I heard that they have an office here, but I did not get their address. And that is known to them.
But you need to serve.
See, because securities are collected, tenders are given, whether if the private respondent today, here is the interim order will be filed, the private respondent will also be. It will affect the private respondent as well as there will be multiplicity of proceeding.
We'll consider all that later on. First, there should be a service.
My lord,
Please come back with the track report. I'll fix it day after tomorrow.
my lord, in the meantime, they will award the work. That is the whole problem. That is the reason. My lord may come to.
When is the tender being opened?
Tender was opened on 31st August.
It's already been opened and
Now-
done. It is a delisted company.
Kindly let me make my submission, then you can always have the opportunity. My lord, may come to page 109. The last page, 109. They have issued the acceptance letter. And they have, at any day, they will accept that, award the award. Then the whole writ petition will become infructuous. I want to draw your lordship only 3 documents.
Don't you think the private respondent needs to be served even on the basis of this document?
My lord, what
Because he will be the worst affected.
only till such time, if this matter is taken up on day after tomorrow.
Can you come back with the track
No, no,
report only,
till
showing
such time-
service? I'll deal with your case.
Well, till such time at least.
No, kindly see the
Then
previous
put
page, page number 107 and 108. In a single,
Performance guarantee has been called.
no,
And the
in a single bench, this company is a delisted company. There is an anti-corruption proceeding going on against this company. And that's why he is not been given the
That's already pending in a.
allowed to participate in the tender process, my lord. Kindly see the page number 107.
The writ petition I have mentioned, your lordship, that is the writ petition which is appearing tomorrow. If
And that order is there, they have made a
that
brilliant submission on previous circuit. They have prayed for ad interim orders. Ad interim order was refused.
at that stage,
This is the same writ petitioner?
no, same writ
Same
petition.
writ petition.
But that is the reason I just want to show 3 documents. Thereafter, let it be after tomorrow. I just want to enlighten your lordship. Kindly come to. There was a.
This rejection of interim order is with regard to the same tender?
There is a checkered history, madam. They have already suspended on the 29th May 2023. That is at page 31.
Yes.
Thereafter, the petition was filed. On 15th June, that suspension order was kindly come to page 37 of the part of the order.
Page 35, kindly come to page 35 first. Kindly come to page 35 first. At
Yes,
the bottom para. As for example, Your
Yes.
Lordship,
yes,
as for example, it is seen that petitioner herein has, in addition to taking the other points, raised the issue as to the jurisdiction of the finance officer of the chief engineer authority, Port Blair, to pass the interim order of delisting. Quite rightly, the petitioner has placed reliance on clause 23.2 of the notification dated June 19, 2017, issued by the Hon'ble administration itself. Sub clause 23.2 of which stipulates that suspension order may be passed by the enlisting authority, pending full inquiry into the allegation and decision by an empowered committee. Unless such an empowered committee is formed and gives an opinion in that regard, there cannot be any final order of delistment of the by the enlisting authority. It has also been pointed out that there are several officers as stipulated in the notification itself, of whom the committee would be comprised of. In the present case, however, no reflection of any consideration by the empowered committee finds place in the impugned order of delistment. That apart, in the event the impugned order is allowed to remain, even in suspended animation, the same would not serve any worthy purpose, since the petitioner was finally delisted by way of a said order, which has to be set at naught for the purpose of a new hearing to be held. In any event, since the petitioner was not served with the relevant documents and was not given a hearing, the order itself was vitiated. Accordingly, WPA 732 of 2023 disposed of setting aside the impugned order of delistment of the petitioner, and there was an opportunity of hearing was given. My lord may come to next page. After that, this order is passed. This is dates are very relevant. This order is passed on 15 June
yes,
by this Honorable High Court. Then kindly come to page 39. This is other notice inviting e-tenders. In this tender, petitioner have participated. Tender was opened. My tender was opened on 25/7/2023. Kindly come to petitioner page 41. Petitioner tender was opened. Kindly come to page 41.
yes,
Tender summary report. Serial number 4 is the petitioner. Tender was opened. The petitioner was second lowest in this tender, and he was not successful. Tender was opened. Then kindly come to page 46. This is another tender.
yes,
In this tender also, petitioner has participated. Tender was at page 53. Kindly come to page 53.
yes,
Serial number 5. Petitioner was sixth lowest. Then, my lord, this next tender is at page 54. Bid opening date is 24/7/2023.
this is the last tender.
This is the last one which I am on. And petitioner has participated in this tender. And this tender last date of opening was 24/7/2023. On 21st/7, petitioner has submitted his tender, uploaded his tender, and kindly come to page 65. I want to draw my lord's attention. Page 65.
Yes,
Kindly see this is a tender summary report. On the top, it is written
yes,
petitioner is in the second, and petitioner remarks column here, status not admitted. Remarks column, it is the eligibility of the petitioner is still under examination, consideration with the competent authority. Still such time the petitioner may not be allowed to participate in the upcoming tender process. In the meantime, upcoming tender process. This is that at this point of time, petitioner was not under suspension. Now kindly come by virtue of the High Court order, and kindly come to the e-notice which I have just drawn my lord's attention. That is which starts at e-tender notice. On the top, the executive engineer, South Andaman Division, page 54.
64.
Page 54, I'm drawing my understanding.
Yes.
What is the criteria? The executive engineer, South Andaman Division, ability Port Blair invites on behalf of President of India online item rate tender from experienced and eligible and experienced government public sector undertaking registered in India for following work. That the requirement is experience. Requirement is not enlistment. That is a, again, I just want to draw my lord's attention because that is a separate repetition which is coming up tomorrow. As I have mentioned, my lord, I have mentioned at the threshold today, I have mentioned that that will appear tomorrow. That is, they are not filing affidavit. I just want to draw my lord's attention once again to page 28.
Yes.
This is the enlistment. The petitioner was enlisted in APWD, it was revalidated, and this petitioner name appears at serial number 3, page
Yes.
28.
Yes.
This is expired in 2020 because APWD has taken a decision. The Lieutenant Governor is the enlisting authority for class 1 contract and petitioner is a class 1 contract. They have decided that henceforth in 2020 they have decided henceforth with the basis of experience only, no enlist, no, that's why no revalidation was done. On 2020 this enlistment is expired. So I am not an enlisted contractor in APW, but applying the enlistment rule, they are suspending. Just that will tomorrow. In the other matter, I'll make my submission. Now I want to draw the very important part. My lord, kindly come, my lord, to page. It starts at 85. It starts at 85. Relevant page is 99.
Yes.
Relevant page is 99. The petitioner, this is petitioner tender. After submitting the tender, petitioner has downloaded the copy. He has submitted this tender for at page 99, 17 crore 11 lakh 46,169. These figures are very important. 17 crore 11 lakh 46,169.
Page 99.
Page 99. On the right side,
Yes,
can you
yes.
see at the
Yes.
bottom,
Yes.
17 crore 11 lakh 46,169.38. And here, I just want to draw my lord's attention once again to the comparative statement of which I have shown earlier. I'll just take 1 minute. My lord may come to page 66. My lord got it? Page 66. Kindly see the financial evaluation bid list.
Yes.
The last page which I have shown that acceptance letter is sent. He has quoted 19 crore 44 lakh 11,514.37.
This is the private respondent.
Private respondent is first rank. Because the petitioner's tender is not opened, there is a difference of 2.32 crore. And for other tenders, the two tenders I have shown, my lord, despite this, those tenders I am allowed to participate. Because I was not lowest, there was no problem. This tender I am lowest, and there is a problem with this tender. And the tender notice criteria is experience only, no enlistment from anywhere.
Yes, that's not the issue.
That is not the
criteria.
criteria. They have again suspended me, following relying upon the same document on 11th September, 11th
September,
23.
11th September 23. Later on, that in this period there was no suspension, and that is under challenge. That is appearing tomorrow. And the last circuit bench, there was we have prayed for an interim order. At this juncture, it was rejected. But my lord, they have given time for 2 weeks to file the affidavit. They have not filed. And I have alleged malafide also. It is question of public exchequer money, 2.32 crore.
WP 947 is with regard to a different issue.
And delistment issue.
That is with respect to the further suspension order on 11th September. That is under challenge. That I have mentioned before, my lord. That will be appearing tomorrow.
The delistment was done in September.
11th September.
Prior there was a delistment
That
that
my lord.
That was set aside.
came to a set aside. Thereafter,
That
again,
was set aside.
that again thereafter.
Page
delistment
100.
was done.
It is not that a petitioner has suppressed any document. Page 100, kindly come. That is the delistment order 11 September 2020 with the same set of documents which was relied upon on 29th May, which was set aside by Hon'ble IT.
You were not allowed to participate only on the ground that it was pending before the authority.
It was pending.
Authorities have written letter to us.
No,
This
no.
correction units have letter to us that he has been delisted and don't allow him to participate.
No. Where is that letter?
I'll show it. How can I show it right now?
No. This is vague.
But after
You
the
have been
order of the
informed.
earlier bench, setting aside the delistment, the petitioner was allowed to participate in 3 other tenders earlier.
Two tenders.
Two tenders. This is the third tender where you have stopped.
This instruction we have to take, my lord. That's why I'm praying time a lot. If interim orders will be passed, the authorities will also be affected as well as this private person will also be affected. There will be another suit. Another writ petition will be filed, my lord.
So will you give instructions to your
And I'll seek instructions from my client, and this is.
that the tender process will not be taken forward till the matter is heard?
How can I assure that?
Because otherwise the petitioner appears to be the highest bidder.
My highest bidder, there is no rule. There are judgments which specifically says that in a public tender, it's not a rule that highest bidder has to be.
What
given
was
the
Is the lowest bidder.
lowest bidder?
Lowest bidder, highest
In
bidder.
all your considerations, the lowest bidder has been granted tender?
Might
In
be.
all the other consideration might be, that is the rule then?
No, there is nothing, my lord. I'll show the judgments which says that it's not a type
Please
law
show me
that.
one instance where where a person not being the lowest bidder has been granted.
But I will
Is that
try to
possible?
find out. I'll try to find out judgments, my lord. If I'm required to find out, I'll find out the judgment, because we have deal with this kind of cases, my lord. It's not that always the highest bidder has to be given the tenders. and all.
This writ petition can be disposed of in this circuit itself. Let them come up with an affidavit day after tomorrow. We'll give a reply within 1 day. The whole issues can be decided till such time. Till such time for a week. Let it not be awarded. Otherwise they will award the work. That is my
But
humble
this,
prayer.
this
from my lord.
requires affidavit, my lord. I am strongly opposing the interim order, my lord. Interim order, there no urgency required in the, for passing interim orders. When he has 2 weeks to file appeal against that order.
Which order?
The previous order, which he is saying that mention the matter today, mention the matter today.
He
it
has
will
challenged
stay.
the delisment.
He has challenged the delistement
Yes,
that
and
interim order has
appeals
been refused, so he can go against the
The
interim order.
has been refused for setting aside the delisment order.
Delisment order. That was the final.
It has nothing to do with the present tender.
My lord.
These letters were, this is on 26th September.
Hmm.
That is after the delistment. So at best, let there be an order that any decision taken shall abide by the result of the report.
That can be passed,
Yes.
the subject matter, subject to the order passed in this matter, that can be passed.
Instead of there being an interim order, let such an order be passed.
And let them come up
And
with an
please-
affidavit if they want to file.
Please, you want to file an affidavit?
I want to file an affidavit, but 2 days are not sufficient, but to prepare that, because I have to take directions from the departments and I'll be required.
In any event, the first matter has to be heard earlier, first. The challenge to the delistement has to be
Let
considered
this,
first.
both the matter be taken up day after tomorrow.
So how I
How
will
will
file
come
an
up with an
affidavit?
affidavit? Sir, not possible. Let
And
this-
the executive engineers upon the cases are going, criminal cases are going on upon the executive engineers of the department.
That is.
It's not like that he has been discriminated by any way.
The petitioner please give me the dates, the delisting date, initial delisting,
29th May, madam,
page,
page 31.
the petitioner was enlisted as class 1.
Revalidation, the enlistment of the enlistment is long back, actually, it is revalidation.
No, revalidation was done after a certain period. Initially, it's in enlistment.
Initially long back.
He
As
started
class
in
1
2006.
contractor
Yeah.
of the Andaman Public Works Department, and his enlistment was revalidated up to 28th October 2020. Stop. He was delisted
Page 31.
upon an order of suspension of his business by an order passed on May 29, 2023. Stop. The petitioner carried the said order, the petitioner assailed the said order before this court and a coordinate bench of this court, comma, by an order passed on June 15, 2023 in WPA 732 of 2023, comma, set aside the impugned order of delistment and directed the authorities to serve copies of relevant documents on which they seek to rely for the purpose of considering the proposal of delistment of the petitioner. Stop. The final order of delistment has been passed by the authority on 11th September 2023, which has been challenged by the petitioner in a separate application. Stop. In the meantime, comma, the petitioner participated in tenders
Page 39.
the first 2 tenders,
Page 39, then page 46.
tenders floated by the authority on 28th June 2023. And the second tender where you are the second bidder?
I'm the second one, I'm the sixth lowest.
Yes, where is it?
It
Page?
is at page 46. I mean, the notice is at page 49. Page 49, 28/7/2023. Page 49,
Is the notice.
notice.
And 28th July 2023, where the petitioner turned out to be the second lowest bidder and could not crack the deal.
One of the first one is second lowest. First one is page 39
Second lowest and sixth lowest.
and sixth lowest is in the page 49.
Where the petitioner turned out to be the second lowest and the sixth lowest bidder respectively, and could not crack the deal. A third tender was floated by the authority on
Page 54. Page 54.
yes, yes.
That is 6/7/23.
The
Publishing date.
date of notice,
6/7/23, that at the bottom, bid document publishing date, 6/7/23. That is each and
on 6th July 2023, wherein the petitioner participated. Stop.
then page 65.
In the tender summary report, comma, the authority disqualified the petitioner from participating in the tender on the ground that the eligibility of the petitioner was still under consideration with the competent authority.
That is uploaded on 31st August. 31st August 2020.
Paragraph, learned. A letter was issued to the private respondent who was declared the lowest bidder by the authority, requiring him to submit the performance guarantee for issuance of work order in his favor. Stop. You have challenged this letter. This letter
This and I challenge page 65. that-
dated 26th September 2023, as well as
Page 65.
the decision taken by the authority disallowing participation of the petitioner in the tender are primarily challenged in the writ petition. Stop. Paragraph, learned counsel for the writ petitioner takes this court to page 99 of the writ petition, which demonstrates that the total bid amount of the petitioner is rupees 1711 169. 0.38. Stop. The bid amount of the private respondent at page,
Page 66.
it appears from page 66 of the writ petition that the
Financial evaluation bid list.
bid amount quoted by the private respondent is rupees 1,944,115,14.37. Comma, the petitioner therefore being the lowest bidder. Paragraph. Learned counsel apprehends that issuance of work order in favor of the private respondent shall render the writ petition infructuous. Paragraph. Learned counsel for the respondents seeks to use an affidavit in opposition in this regard. Paragraph. Affidavit in opposition be filed within 1 week.
Because the person is also outside.
Within 2 weeks from date, stop. Affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph. Any decision taken / order issued by the respondent authorities with regard to the tender in question shall abide by the result of the writ petition. In the meantime, please ensure service upon the private respondent. Affidavit of service first. Next.
What I'm appearing along with this. As for the respondents.
Petitioner?
For the petition, my lord.
Yes.
My lord, this is the electricity connection matter. My lord, I have enclosed a piece of revenue government land, and accordingly, I have applied for the electricity connection. I have constructed the dwelling house in the same page, and kindly come to page number 10, my lord, where I have applied the electricity application, my application. Page number 10, I have applied on the date 27/7/23. But till date, they have not provided the electricity connection. As such, I have come to the court. And according to the larger judgment, my lord, I have entitled to get the electricity connection. This is the government revenue land.
Yes.
But submission is what we have to follow the larger than judgment. We are not saying it all comes under the principle which is later on larger than judgment, that it is bound to be settled.
That's settled law, isn't it?
But in this case, we don't know whether they have been applied or not. So there is no endorsement as such in the
Page number 10.
number 10. But if they apply, we will consider in terms of.
This is a matter of Hon'ble, because there is no online application they are accepting. As such, we have applied physically.
Should be some receiving scene.
Yeah.
And if it is physically,
My lord, in office, they are accepting the application only.
they are not putting any seal to it.
No seal, my lord. No, my lord. Yes, actually, they have to sign. They have to, during the time of accepting, they have to sign.
Do you consider the application?
My lord.
You consider if it has been filed, we don't know, my lord, subject to my
So
lord.
let a further copy be placed before you
Yes, my lord.
by the petitioner.
Right.
Right?
Consider in accordance with the.
Please file a further copy of the application.
My lord.
The petitioner claims to be an encroacher on a piece of revenue land and submits that he applied for electricity connection before the respondent authorities for his residential house, for her residential house constructed thereon, stop. Though the application was filed on 27 July 2023, comma, no step has been taken by the authority in this regard. Paragraph, it is submitted on behalf of the respondents that it cannot be ascertained whether the application has been filed by the petitioner or received by the authority. Paragraph, upon consideration of the submission made on behalf of the parties, comma, the writ petition is disposed of, directing the second respondent.
Yes.
Assistant.
Where is the judgment of the division bench?
My lord, they are having.
Yeah,
My lord,
what does it say?
Say they have been found in the second position whenever.
This has to be added to the submission of the petition before the respondent's submission. Learned counsel for the petitioner places reliance on an authority in Abhimanyu Mazumdar versus superintending engineer reported in laws LAWS within bracket Cal CAL. Please see this. 2011 236, wherein an honorable division bench of this court has observed that so long as a trespasser in settled possession is not so evicted, comma, he should be entitled to get electricity with the aid of section 43 of the Electricity Act on compliance of the terms of supply as provided under the law. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, the writ petition is disposed of, directing the second respondent to consider the application submitted by the petitioner dated 27th July 2023 and take necessary steps for providing electricity connection to the petitioner for her residential house in the plot in question within 1 month, 2 weeks. 3 weeks. Within 3 weeks from the date of communication of this order, subject to the petitioner complying with all requisite formalities, comma, in accordance with law. Yes, that will be recorded, definitely. The petition paragraph, the petitioner is directed to provide a copy of the application dated 27th July 2023 to the second respondent, along with a copy of this order at the earliest. Paragraph, the writ petition is I have stated it's disposed of. That is already stated. There shall, however, be no orders to costs since no affidavit and urgent certified website copy.
madam. Greatly.
Do you want to take back the judgment? Directing the, please read out that part. Directing the second respondent to
Online है, page number 10.
Add one line in terms of the judgment of the honorable division bench in SUVRA, just the name, first name. Next.
21. But in this slide, changes what they have filed an online application, but that is pending for consideration.
Online application, you are the.
My lord,
petitioner?
I am the
Yes.
petitioner. My lord, this is the matter of South Andaman under garage.
They are in future, as my lord has already passed in previous orders, same order we passed, but there is a slight changes is that, my lord, that application has been filed in offline mode, but in this case, they have filed an online application. That is a page number 10 of the writ petition. Same order will be applicable.
Same order, little changes. The application was filed on 21st June 2023. And that line will not be there. The respondent submission will not be there. Same order.
Obliged, my lord.
Item 22, WPA 9/20/2023.
Same order, my lord, as
Similar matter, my lord.
last matter.
As 21,
Yes, ma'am.
online application filed, the date of the application,
Page number 10, it is.
26/7/2020. Page number 10, my lord.
26 July 2023. And that it cannot be ascertained, that line will not be there in the earlier matter also. Yes,
Greatly obliged, my lord.
Item 23/85.
I am for the respondent in this matter, my lord. Mr. Kumar is there, my lord. He is not there, so my lord.
for the petitioner.
For the petitioner, Mr. Kumar was there.
He'll be here next week.
Or also in NM we are also waiting for the decision of that NM global judgment by impounding of decision. That's also going in Supreme Court. So
This
that-
is under section 11.
Yes, my lord. That will affect this case, my lord.
So when is that judgment due?
That
It's still, the
judgment-
hearing is going on, isn't it?
Matter is going on before this.
But the petitioner is also not there.
My lord.
So next circuit,
Next circuit, my lord.
because by next week it will not be.
My lord, it
possible.
will not be.
Petitioner is out of town.
No, he is here. He just gone out.
So let him come and make his submission on this application. He is the petitioner.
He is the petitioner. Or my lord can post this next week as well. So
Very good. None appears for the petitioner. Paragraph, let the matter appear under the same heading. On 17th,
17.
Item 24, as of 2019, is CAN 1 of 27.
My lord, in this matter, my senior is appearing for.
My lord, in this matter, my senior Ajay Kumar Mandal is appearing for the OP number 1. Not today, my lord.
so good, both the seniors are not there, so let us hear from the junior friends.
My senior is like before court for approval.
Maybe, take this chance, make your submission before the court.
My lord,
You are not ready with the matter?
yes, ma'am.
Yes, you are ready.
No,
You should take these chances, isn't it? You want it before the next circuit,
No, no, my lord. Tomorrow, tomorrow.
not today.
Item 25, SAT 8 of 2021.
I am for the respondent. My lord, here I pray, my lord, this matter may be taken up in the next circuit. Mr. Vijay Kumar is appearing for the
It's
petition.
an application, isn't it?
No, your worship, it's a hearing of the second appeal.
I find an application pending, CAN 1 of 2022.
But the counsel is not well, my lord. The counsel who is appearing in this matter, he is undergone treatment.
Your worship, only my prayer is that let there be a direction to file the paperwork so that in the next circuit, the matter can
That
be
is
heard
not,
and disposed
no
of.
direction given.
I don't think, Your Lordship, because I. नहीं, नहीं,
This is a continuous menace in
Yes,
Andamans. At
We are
night it
also
goes
facing
off,
a great- yes. In our house also the same position.
same thing.
All electrical appliances are getting.
Naturally,
Right.
they'll get damaged, yes. This sudden thrust, no, it gets damaged, yes. There was a direction to serve copies of memo of appeal and application. It may be that the documents on record should be are sufficient for the appeal,
No, Your Lordship,
because there's no direction.
because second appeal it is, so there has to be some.
Yes,
paperwork
will you
direction.
prepare the paper books in the meantime?
My lord, I am not in the record, my lord. So
I cannot give a
counsel
direction.
who is
Because
appearing,
I find in last two circuits, learned counsel was
Yeah,
not
we are taking
available.
adjournment that-
For his medical emergencies, yes.
Let it be as a matter of last chance, Your Lordship, because I have to reply to my
Medical
client.
ground cannot be last chance,
Yes, sir,
madam.
that is a difficult. Your Lordship,
I may suffer tomorrow, you never know.
Your Lordship.
I am informed that learned counsel for the petitioner has undergone surgery. That's what is recorded in the file. And is unable to attend court. Stop. Paragraph, let the matter be placed before the next available circuit bench.
obliging.
Obliging.
But both my senior and the senior father side both are not there, so my lord.
So why can't the junior friends start?
I am not on the panel, your lordship, I have already stated that.
Who is appearing for the petition?
Where Mr. Binu Kumar is there for the petition.
Where is he?
Not the matter, because I think there is a contempt matter before the principal bench, division bench. my lord. So he-
In connection with this matter?
No, other matter, but that is the suo motor matter. They have been appointed as court officer in that matter. my lord.
Will you
Special
come back
officers
next
there.
week?
Next week or tomorrow, day after tomorrow, whatever preferable is.
Friday,
Your lordship may-
Friday. Please inform him.
My lord.
None appears for the petitioner. Paragraph, let the matter appear under the same heading on 13th.
Same, my lord. But in this, I am for the petitioner, he is
Yes.
for the respondent. So, my lord, in his absence, my lord.
Matter is similar, the issue is similar,
No, no,
different.
both are different. This all are hearing matter. He came.
My lord,
Yes.
In absence of my senior, I can only pray for.
let it be tomorrow, my lord. It's a old matter,
Will come to-
can be done, my lord. It's a service matter regarding,
Fixed on Friday,
my lord,
26.
my lord.
So at least a little change. On prayer of the respondents, the matter is, I had recorded that
No.
you were not there. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 13th.
My lord,
What about the next matter? Same.
Same.
So 13th, the same day.
my lord. No, no, it is not a same matter.
Matter is. not
He is
same,
the
but-
petitioner.
Yes, yes, other petitioner.
Yes, my lord.
Parties are same.
On prayer of the petitioner, the matter is adjourned. Same date, huh?
लड़ने का है। इसके judgment हो गया।
This can be taken up because during the last subject, taking both the council for the appellates were ready with the matter. So lot of time this will not be taken up.
Who is appearing for the respondents?
19 of
Mr. Khan,
For the respondents?
appellates, I'm for the respondents.
Or you are for the respondent?
I am pro forma respondent.
Yes,
Madam is
Pro forma respondent.
there is the appellant.
the old appeal notice 2019.
Yes. There is an earlier order saying that the council has lost touch with the appellants.
But Worship, the last circuit, last order may kindly be seen, Worship. They were ready with the matter. I could not attend the last day. On my ground, it was adjourned. Now I'm ready, Worship. This can be taken up.
I do not find the appellants at all.
I'll just send my letter. Let it come tomorrow in such case. Not today, just not.
Is he there in court?
He has come to. He has come courts also.
I've seen.
He has seen.
I've seen.
So shall it be only not today?
Just not today.
Tomorrow, my lordship.
Tomorrow?
Yes,
Not today?
I'm in a hurry.
Just not today.
I'm.
I am appealing for the respondent, my lord.
Circumstances.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the Friday,
My lord,
Friday.
Fine.
Let the matter appear under the same heading on 13th. If all the matters are adjourned, how can it be taken up?
from tomorrow, my lord, it will take place, my lord. I can assure that much.
Item 32, WK 179 of 2019. I am there for the additional of this matter can be taken.
My senior is not there, my lord. These are
Remand by-
hearing matters, my
Sorry,
lord.
remand. I lost that on the first, it was challenged before the division bench. Was remanded back to Worship. I am seeking, no, they have no say in the matter. Their own order, I want implementation. For which the report was published. Now the matter is before me.
But then, my lord, this can be fixed tomorrow, my lord, because these are hearing matters, my lord. I can't, my lord.
Hearing very small matter, it's not a big one also.
No, I know that.
Not today only?
Yes.
Yeah.
My lord, I am appearing for the petitioner in this matter.
Oh, no, these are all hearing matters.
My lord,
Can.
there are several hearing matters, my lord.
That's what I find several hearing matters pending.
Yes,
You're the petitioner?
yes, ma'am.
Who is appearing for the respondent?
Mr. Kamraj is appearing, my lord. Perhaps he's not there. I will inform him, just not today, my lord. He's not there. I have not seen him today.
All matters cannot be kept as not today. Several matters have
Let
been
it
made not
be
today.
any day and next week, my
Day
lord.
after. Day after Thursday. Yes,
My lord,
Thursday.
my lord,
None appear, you are for the petitioner?
my lord.
None appears for the respondents. Paragraph, let the matter appear under the same heading on 12.
Item 34, WK 219. This petition is on remand. This can be.
No, my lord.
Division bench order, my lord, I am seeking the benefit of those orders.
Not today.
And 35, we have to file a report. That report is ready, but right now that report is not with me. So tomorrow I'll file that report, my lord, because there is a difference of opinion between the forest department and revenue department in regard to certain woods and lands. So, my lord, we have to file a
Who is
report.
you're the petitioner on this matter?
Is
My
the
property
petition?
has been taken by the revenue department. And there is a clash between revenue and forest department. They said that I have not taken, the other side says I have not taken. This court directed them to hold a local inspection in my place. That was done. And the report,
Report is ready, but
I've been given a
it's
copy
not
of-
with me right now.
Day after?
Yes, yeah.
On prayer of the respondents, the matter is adjourned. Let the matter appear under the same heading on 12.
Item 36, WPF 240 of 2019.
I am appearing for the respondent.
But I am for the petitioner in this matter. Thank you.
Not ready today. Day after?
Yes.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12.
Item 37, WPF 246 of 2019, WPF 246.
Here, my lord, there was a direction to file even report. They have not filed. It's a pending matter. My land has been taken away by them without adopting any procedure.
I take inspection in this matter because there are two matters.
Please,
similar to-
please give me the file.
Whether the reports have been filed or not. ma'am.
No copy was served upon me.
Yes, a report was called
My lord.
from the relevant Tehsildar,
Yes.
not filed as yet.
But I will take inspection on this matter. I'm not
Report is
aware.
there. When was it filed? A survey report is on record.
My lord.
16th March 2022, it was filed.
The APW department, my lord, who have taken my land without any procedure, they have not filed any opposition, my lord. Though there was a direction initially, perhaps. They are representing Tahsildar, my lord. Tahsildar submitted this report on the basis of an order passed by this honorable court. But the case is against the Andaman Public Work Department. So they have not used any opposition. I remember, my lord, Justice Basak's order is there,
Right.
on the basis of which this report was called for. But the contesting respondent is the Andaman Public Work Department.
Please take instructions and
My
come
lord,
back.
take instruction.
When will you come back?
As your lordship, my lord.
Day after
Yes.
tomorrow, my lord, let it be, at least they come with some instructions.
Then,
And
on prayer of the respondents, the matter is adjourned, paragraph. Let the matter appear under the same heading on day after this, 12.
my lord.
And for the respondent, the counsel is to Kumar, in fact, is undergoing surgery in his leg.
He's for the appellant.
Yes, so this has to be taken with the next, and we have to 7 months.
I am informed that learned counsel for the petitioners is undergoing surgery. Paragraph, the matter be placed before the next available circuit bench. Yes. None appears for the appellant. Paragraph, let the matter appear under the same heading on 17th.
It's urgent matter, my lord, the last one.
But
So
you're
my
not
senior-
appearing.
See, I am in another court, my lord, just,
You're appearing for the appellant.
yes, my lord, my senior is appearing for the appeal, my lord. Just let it be
Yes.
fixed on tomorrow, my lord.
The respondents are also not there. Have you
Yeah.
served the respondents? Paper books ready?
My lord, is ready, madam, my lord. Yes,
Paper
my
books
lord.
ready? Respondents are not appearing.
Let it be.
Come back on Monday. Come back on Monday. 16th.
Always, my lord.
And for the appellant.
It's ready for hearing?
But there is some development occurred. These appellants and respondents are husband and wife. No, there was a divorce. Let it come tomorrow, let it retain its position till tomorrow. I'm just.
Not today only.
My lord, I am appearing for the petitioner.
But I am for the respondent. Previously, Ms. Nag was appearing, so I've just received the brief in this matter.
No, you are appearing in this matter from last 3 to 4 months.
I don't- Whatever my dream, my lord, I'm just paying for not to them.
Paper books are ready?
My lord, it's a writ petition. Pleadings are completed.
Oh, it's a writ petition.
My lord,
Affidavits were called for.
my lord, I think pleadings are completed.
It may be taken up tomorrow, my lord.
Next week,
My lord,
Tuesday,
my lord.
on prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 17th.
My lord, I am appearing for the petition. my lord.
Very good respondent.
Yes, what is the matter about?
Matter, my lord, with regard to regularization of their service, my lord. Because their case is covered in terms of the judgment of the case of Uma Devi, my lord. So that is our case. Pleadings are completed, even supplementary affidavit and all they filed. There are 4 matter, my lord. Rest 3 matter I will mention there and delist and
Oh, it's in the other bench?
Yes, my lord.
Second bench.
there are 4 matter, my lord. I pray this may be taken up, my lord, in this circuit. Any date as per the convenience of my learned friend.
Will
may
it
be-
not be easier to shift this?
No, no, my
particular
lord.
matter there?
No, my lord. Let us see.
Affidavits complete,
My lord, completed.
Friday?
My lord.
Yes,
My lord.
short matter?
My lord,
No.
short matter. For me, it's short matter, my lord. We have worked during the said period, 10 years work completed. Now they are taking lame excuses saying that when you were incepted, you were 17 years. Therefore, we could not give you regular. That this, it is not
Does it
disputed
start
that.
today?
No, my lord. No, my lord. The brief is not with us. We are confused.
On prayer of the respondents, the matter is adjourned. If hearing matters are shifted, it's difficult to complete.
Yes, my lord.
Yes.
We miss a day, it's difficult. Let the matter appear under the Monday,
My
16th,
My lord. My lord.
under the same heading on Monday. 16.
These bunches of matter, right, 45, this is a very short matter, this kind of taken.
I have 45 to 50, my lord, affidavit in oppositions are not been filed, my lord.
Not necessary. Let us hear the matter.
My lord, the brief is also not with me, that is the problem.
I can start subject to what.
That
you
you
can start with it.
That's it.
I can
Yes,
start.
what is the matter about?
Lord, what has happened? The authority have passed orders. But the order has been challenged on many grounds. Lord, can you take some one case? I'll just give you the number. It's.
It's all together. I'll take up the first matter.
Yes.
105.
My lord. Lord, in these islands, Lord, the scheme for regularizing a land, be it by an encroacher originally, be it by a recorded tenant in access to their recorded land, is recognized. My case pertains to a scheme dated 15th of July 2003, which the government of India has introduced in this island. And that scheme is meant for only one class of category in this island, that's the pre-1942 settlers. They're the first descendants of this island. I'll just show that scheme once. I'll just in order to take the benefit of this scheme, Not one has to be in 19 pre-42 inhabitants. If he or she is not alive, then his or her descendant. Now kindly see page 13. It's an identity card issued by the authority.
1313?
13, annexure E1.
Yes.
My lord can find the name of my client reflected. This is an identity card issued by the authority. My lord kindly consider a category. All inhabitants pre-1942.
Yes.
My lord, got it? My lord, now kindly turns to the very scheme which is at page 16, annexure P3. The one which I have referred just now, it's dated 15 July 2003.
16.
1616. I'll
Yes.
place this scheme. It's a 10-line scheme, Lord, issued by the Government of India. It is addressed to the Chief Secretary and Andaman Nicobar Administration. Subject: regularization of excess land in possession of 1942 settlers without payment of premium. Regarding correspondence numbers have been given. Sir, in pursuance of the announcement made by the Honorable Prime Minister during his visit to Andaman Nicobar Island in January 2002, the matter regarding the regularization of excess land in possession of pre-1942 settlers within the Port Blair municipal area has been considered by the government and has been decided that the excess land of the Port Blair municipal area, which was in possession of pre-1942 settlers up to the year 1961, as identified in survey undertaken by the Andaman Nicobar administration in 1961, might be regularized without levy of any premium. The regularized will be subject to the following conditions, 1 and 2. The excess land will be regularized only to the extent that the concerned occupants and their descendants have maintained their continued possession till date. Andaman and Nicobar administration will carry out a survey to identify the pre-1942 settlers / their descendants and the exact area of excess land in their possession up to 1961. Lord, in order to avail the benefit of the scheme, the sine qua non is I have to hold a property and there has to be an excess land adjacent or contiguous to my said property.
And continued possession.
Continued possession, and I must be a pre-1942 and the land has to be within Port Blair municipal limit. It can't be beyond that.
Yes.
Not the present writ petitioner owns a property. I'll just show that at page 14.
1414?
14, annexure P2, which is within the Port Blair limit. I'll just show that. Annexure P2.
Yes.
Manad can find my name, Prem Kishan. At the left side,
Yes.
Manad would see it's Abadi. It's a recorded land.
Yes.
Survey number is 94/1/1. Area is 500 square meter.
Yes.
Lordship, I have sought for regularization. The authorities have prepared the impugned report at page 17.
Yes.
My lord, it's a report dated 3rd March 2020, prepared by the surveyor Patwari and Tahsildar. My lord, so far as the present writ petitioner is concerned, my lord can find his name at serial number 1.
Yes.
My lord, it says, I am the recorded of survey number 94/4/1, 94/4/2. Area has been mentioned in the 4th column. Occupation over survey number is mentioned. It's vacant. The problem is not with regard to the 5th column, right? Just below survey number 94/4/2.
Yes.
The revenue authority says that I am in occupation of these survey numbers, which is recorded in the name of third party. And page 18 may kindly be seen, Lordship. It was further asserted by the administration that I am also occupying a government revenue land in survey number 103 and 101/P, measuring area so and so at the same village. And it has been held, Lordship, that I am an encroacher of this land. Now, this report in part is in my favor to the extent holding that I am in a government revenue land, because the scheme which I have referred to just now is pertaining to a government land. Because I may be a recorded tenant of a piece of land, but the excess land is always with the government. The government possesses. So the survey number 103 and 101/P so far as areas are concerned, Lordship, that has been shown to be in my possession. But once the problem is with regard to the first page at 17, the authority have held that I'm in occupation of these survey numbers. 93/3/9, and my lord would see the corresponding remark recorded in favor of one Mr. Nisar Ahmed. 93/3/3/9/1, area is 0.068, recorded in favor of Amar Kumar Sadhu and Pratima Singh. In the same way, if my lord sees serial number 1 tabulation, I have been shown to be an encroacher of these landed property. But these findings have arrived by the authority based on a demarcation. My lord would see at the top at page 17. As directed in the above
The
reference.
last two columns you've been shown as encroacher, 103 and 101.
Yes, my lord.
The remaining land also you claim to be in possession.
No, they say that I have occupied the land of a third party. To come to such conclusion, they held certain demarcation, my lord. I'll come to page 17 at the top. As directed, page 17 at the top, my lord. As directed.
This is very ambiguous. I mean, Prem Kishan, it's not, it's the last column constructed a double-storied RCC building,
Yes, my
etc.
lord.
That is in 103 and 101.
Yes, I do it.
But in respect of the other plots,
My lord.
94/4/1,
Yes, my lord. It's
94.
mutually destructive, my lord. Mutually destructive.
Here, it's not very clear as to whether Prem Kishan is occupying these
No,
plots.
yes. Not kindly see now, my lord. My lord
Because
would
they are
find-
recorded in
No,
favor of
my lord,
others.
kindly see serial number 1.
Yes.
Prem Kishan, my lord, has to see the entire box. It's meant for Prem Kishan only, because at the bottom, serial number 2, Hari Kishan. So first box as against serial number 1 is meant for Prem Kishan only. So entire box at page 17, first serial number is, they say, Lordship, I am in a recorded tenant of a piece of land. They also say I'm in a government. They also say at this occupation was survey number and areas. Other survey numbers has been shown on page 17. To come to such conclusion, they held certain demarcation, which would be evident from page 17. Lord, if they held a demarcation, if they show that I am an occupation of another land, I am entitled to get a notice. Demarcation has to be done in my favor. The first and foremost ground to set aside this report, Lordship, I have not been heard. Lord, hearing this audio from Patram has no magical term in it, Lordship. I have to be given a notice. I must be given effort and opportunity of hearing, Lordship. And if any adverse material is collected against me, I have a right to get a copy. I have a right to deal with it. These rights have been curtailed. To the extent of these recording, Lordship, that I am in occupation of the land of one Mr. Nisar Ahmed, Amar Kumar Sadhu, Samir Sagar Dungdung, G. Lisi Vijayan, Satya Narayana, Aisha Binu, Pakiyam Daniel, Kusumutu Taya, these findings have been arrived based on demarcation. Rest, Lordship, it's in my favor. I'm seeking regularization. My Lord, kindly see my prayer. I'm seeking for regularization. I'm a pre-1942 settler. I'm having these government property. I fulfill the requirement of this scheme. They are sitting tight over the matter. Rather, they have come up with this stand. They say that I'm in occupation of these landed properties. If they want to say so, they have a right to say so. They are independent in their action. But at the same time, while coming to such conclusion, they must disclose the adverse material which they have collected against me. This is.
Why don't you file a comprehensive representation before the authority?
I would, but so long this report is there, it is staring in my face. Lord, liberty can be granted. I will use my representation, omnibus representation, but this report to this extent has to go. This has to be set aside from the papers, Lordship. Otherwise, this would be in detrimental to my interest, Lordship. The authorities are in my favor. Their report in part is in my favor, but the rest part is staring in my face. So this is my point, Lordship.
The report cannot be set aside like that, isn't it? Evidence is required. They say that it's recorded in favor of these persons. That is on record.
Yes, no, there's no dispute to it. What they say is they have went ahead. They say that I have occupied it. That's the problem. Lord, kindly see again occupation. Serial number 1, Prem Kishan, just by the side at the top. Occupation over survey number and area and hectares. They say that I'm in occupation of these landed property. These findings they have come across through the demarcation only at the page 17 at the top. First line may kindly be seen, Lordship, page 17. A demarcation was held. If it was held, Lordship, I am entitled to get a notice. But kindly see page 17 at the top. As directed in the above reference, we understand have conducted the demarcation of land bearing survey number 94, 103, and 101. And then on at Nayagaon village on 6/3/2010 at 10 AM under the supervision of Sri Halikat in the matter of arising of WP number 136 of 2019, Balachandramasa Ramanu gas station. On the verification of report, survey number 94 has been subdivided amongst the recorded tenant. As per survey number 94/1/1/1 area,
So will a fresh demarcation serve your purpose?
no, sir, demarcation has to be done in my presence.
That's what I'm saying.
But no, sir, but without getting influenced with these findings, because this is against me, no, sir.
Yes, what do you say? Admittedly, the demarcation was not in presence of the petitioner, right? So let this demarcation report be set aside. Let there be a fresh demarcation upon service of notice to the petitioners.
It will be better if you give me one day time. Can you fix this matter tomorrow at all of the day? Because
What is the because?
if this report will be post what remains in this matter.
Nothing. A fresh demarcation has to be done.
Well,
Let there be a fresh, it is, you cannot dispute the fact that the demarcation was behind the back of the petitioners. They are entitled to a notice of demarcation. You demarcate their land, you hold something against them without their knowledge. This violation of natural justice.
let me just take this question of
What other instruction do you require, sir?
whether when it says appearance or not, what was the circumstances?
Not today, tomorrow at the top.
All these matters.
Yes. 45 to?
15.
There are analogously taken.
No, sir.
Yes. Under the heading hearing at the top. The first matters for hearing. Been disposed of here and now. The same order will be passed tomorrow.
What can I do?
Hey, if you are happy with it, so be it.
So these are my instructions. We are just the nature of the instruction.
No, but please inform your authority that this is the matter.
I will inform.
A demarcation has to be done in presence of the petitioner because it's their land.
Item 51, WP 109.
My lord, I am appearing for the respondent in 51, my lord, and petitioner in 52, my lord.
Yes.
My lord, an award was passed by
Who is
the.
appearing for the other side? You are
They are
appearing.
appearing. My lord, here, the award was passed way back in the year 2021. Now, my lord, they have challenged it. At no point of time, this court has stayed the award passed by the Labour Court. Now, my lord, I have taken out an application under section 17B of the Industrial Dispute Act 1947, that intervening period, I have to get the wages which I have drawn on the last day. And it is a settled proposition of law, my lord, even if they succeed in this writ petition. But I am entitled to get the remuneration for the intervening period. That is the settled proposition of law, my lord. This application I filed long back. Till date, they have not filed any opposition, my lord. I pray, my lord, let the matter be taken up because they are out of service despite of an award passed by the Labour Court, my lord, from 2021 onwards.
You've challenged the award also.
My lord, some portion, my lord, I have challenged it.
You've asked for quashing the
Back-
award.
No, they have challenged it, my lord.
Oh, this is their application.
My lord.
Yes, right. You've taken out an interlocutory application.
My lord,
or-
under section 17B, my lord. So I am entitled for that wages, my lord, last drawn.
And 17B has to be disposed of before the writ petition first.
My lord.
At the
And
first
the law
hearing.
is settled, I am entitled for that.
Yes,
Because there are three persons, my lord. For one, I have not filed because he is earning, he is doing service, so therefore I have not. But so far as two ladies were there, two women are there.
are you opposing the application under 17B? You do not know.
Have knowledge about this matter. These are hearing, this matters comes long before I come to court. These are the problems.
But please be prepared, sir, because if hearing matters are adjourned like this, then they will never get disposed of. Next week, come prepared. The 17B application, okay?
My lord.
On prayer of the petitioner in WPA 107 of 2020, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th, at least we can dispose of the 17th.
My lord.
Please find out if the 17B application is in the file. I do not see it.
CAN number is there, my lord. It is in WP number 107 only, my lord.
Please find out if the 17,
Yes.
if the can is there in the file. Can 1 of 2022.
My lord.
Here for the respondent authorities, my lord.
Petitioner,
My seniors for the, my lord,
yes,
just not today, my lord.
not today.
Obliged, my lord.
My lord, I am appearing for the petition, my lord.
I am appearing for the respondent authorities.
Yes, what is the matter about, you are ready today?
My lord.
My lord.
Affidavits exchanged?
Yes, my lord,
Explain, my lord.
completed.
My lord, here in this case, my lord, the petitioner has purchased a landed property from a third party, my lord.
Yes.
While he purchased it and it was in the process of executing a sale deed, the authorities has given certain requirement that because of which the sale deed cannot be registered. Thereafter, my lord, we fulfilled all the.
You have not filed a reply.
My lord, in that case, let it be just not today. Reply is there, my lord. Perhaps I have not filed in the record, maybe.
I do not find it on record.
My lord, let it be tomorrow. Yeah,
And there's a recording also in the order that reply has not
my
been.
lord, my lord. Then in that case, let it be in the any day, my lord. I will file it by
Day
tomorrow
after?
morning. I
Day
will
after?
day after tomorrow.
My lord.
Affidavit in reply is yet to be filed by the petitioner. Petitioners. Paragraph, let the matter appear under the same heading on 12th.
My lord.
Keep your advised, my lord.
But this file is not with me. my lord.
Which
Actually,
file?
The department.
55?
55, I am appearing for the petitioner.
The department has not supplied the file. I'll ask them to.
This is
supply the file.
2021 matter.
Next week. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th.
My lord, this is second appeal, my lord.
Yes.
I am appearing in item number 57, 56 for the respondent and in 57 for the appellant.
Who is appearing for the other side?
Hon'ble Aldar is appearing for the.
So let it be not today because there was a request from the bar not to take up matters after 2 p.m.
My lord, my lord, my lord.
I believe you are busy in the district court after in the second half.
My lord. My lord, only one request, my learned friend is there. In
Yes.
item number 1, perhaps item number 1, I was not there when the matter was called.
Yes.
Now, my lord, item number 1, my learned friend or my lord, whatever submission he has made, my lord has fixed it under the heading hearing, I think. My lord, actually
Because
what?
affidavits are complete.
No, my lord, what happened in this case? My lord, in the month of September or October last year, I have moved this application. There was a direction upon them to file opposition within a time frame by January. They have not filed. Now, my lord, thereafter, I mentioned this matter in the last circuit and the court was pleased to direct them to file opposition within 2 days, reply within 2 days, and the matter was posted on Thursday, my lord, on 28th. My lord, but on that day it was holiday, my lord, and therefore the matter was taken up on 29th under the heading to be mentioned. But since it was the last day, therefore, my lord, Justice
No,
Tandon.
but it requires hearing, is it?
My lord, it's a short matter, my lord, because the matter is, my lord, whether a industrial dispute can be referred to the labor code or the appropriate government enjoys a power to say that we will not refer it in an administrative capacity. It's a small issue, my lord, because of which the matter is lingering on from more than a year.
I have fixed a date already. I do not.
My lord,
remember.
only request, my lord,
It's tomorrow.
only request, my lord, if it comes under the heading hearing, my lord, then there are chances it will not reach, my lord. And that's why my lord has,
No, under hearing, I think. Under hearing, yes.
so that's
Because
why I'm mentioning, my lord.
Let us take a chance.
My
If
lord.
it doesn't appear, I'll consider it.
My lord, my lord,
Yes.
my lord, I'm grateful.
What about the other matters? Shall I take them up? Can you come back after 3? Yes, no,
Very well, my lord.
yes.
No, my lord, I am ready, my lord. In my matter, if they are ready, we can do it, my lord. Because there are several hearing matter, then it will never be.
Vincent is not ready in any of the matters.
But
He has his
Senior
second
is-
towards his senior.
Not that well.
There are several hearing matter, my lord. It will be difficult.
That's what I find.
The
There are
tendency is
several
being raising like
matters.
anything, my lord.
Yes. Because this is the reason why hearing matters are not being taken up.
Yes,
And once we cross this week, it will be difficult in the next
Yes.
week. Because I have 4 working days.
yes.
So how can hearing matters be taken up like that?
I believe from tomorrow, my learned friend will assist the court,
Will be in full swing. Let us see.
my lord.
Very well, let us call it a day.
My lord.